2 p.m.
Deeply obliged.
Inform all other concerned advocates.
One and three.
One and three.
One and three. Happy.
কিন্তু অর্ডারটা 1, 2, 3 একসঙ্গে হবে।
এই নিন, আমি একে আছি।
Item number 4.
কটার সময়?
4 নেই।
বড্ড বেশি হয়ে গেছে।
কটার সময়?
Item 5.
পরে কেউ ছিল না নাকি?
পরে কেউ ছিল না।
I have put the appeal in. I have not mentioned the matter.
Appeal is ready for hearing.
No, my lord, paper book is not.
Admitted. On the last occasion, a report was called for, but the TCR is ready or not.
There's a report of the department dated 7 July. Says PCR is yet to be received. Why? এত দেরি কেন? Casual. তাহলে কি আমরা করবো? একটা রিপোর্ট চাইবো? 8 দেখো। By an order dated April 28, 2025, while admitting this appeal, a coordinate bench had called for the trial court records. Top direction was also issued for preparation of paper books within 4 weeks from the date of receipt of the trial court records. Paragraph. Date, already date April 28. Paragraph. We find a note of the Assistant Registrar Roman 7, dated July 7, 2025, to the effect that we find that in the file we find to the effect that the trial court records have not yet been received by the department. Paragraph. The department shall file a report on the next date as regards the status of the case.
Section 5 is pending.
No, allowed.
Section 5 was allowed.
Allowed.
Section 5 was allowed.
List the matter next Tuesday. এটা কি তোমার ডিপার্টমেন্টে পাঠাতে হবে? তুমি অর্ডার কে পাঠাবে? পাঠিয়ে দিও।
Lord, in this appeal, my lord, we have filed yesterday an application for suspension of sentence. So, my lord, may I provide the CRAN number so that my lord
We listed, yes.
my lord, I have the CRAN number 1 of 2025.
So far as the item number 5, is the convict is on bail?
No.
Custody.
Is in custody. I have filed a bail application.
How long?
My lord, that I have to, my lord, go through the brief, my lord.
Custody trial.
No, custody. During trial, he was on bail.
It was on bail.
Okay.
Okay.
Item number 6.
Item number 6, I beg to appeal the applicant, my lord. Not similar matter like item number 5.
Oh,
Report,
right.
my lord.
Identical, same. Dates also same. Next Tuesday. This is what? Murder? No.
It's a kidnapping case,
Kidnapping.
not murder.
Oh, 363.
Okay.
Item 7.
Seven, my lord.
Similar, my lord. Similar, देखिए.
Lordship, only a humble prayer that petitioners are a daily wages earner labor. My lord, they will prefer appeal bail. Lordship kindly fixes it only 2 weeks after, my lord. 2 weeks time, my lord.
We filed application for suspension of sentence.
Yes, my lord.
So.
Yes, my lord. My
What is the age of the victim? What was the age of the victim? What was the age of the victim? This is a POCSO case.
lord. It is a murder case.
It's a murder case, not POCSO case.
Sher Khan.
Oh, special court POCSO. Sorry.
You filed a claim, it's not in the list.
Special group for
It's not in the list.
Cran has been filed, my lord. Cran has been filed. I'm seeing, my lord. I'm giving the number, my lord.
When should the CRAN be listed? Tell us.
Lordship, 2 weeks after.
2 weeks. The data can returnable 2 weeks after করে দাও.
How long he is in custody?
My lord, they are on the verge of completion of 10 years. In January 2026, they will complete 10 years custody.
এই শোনো.
দেখিয়ে নিন। কোনো কিছু আসেনি, এটা অ্যাডমিশনে আসেনি। পরে
তুমি এটা দিয়ে দিও, নম্বরটা দিয়েছেন অ্যাপ্লিকেশন CRAN
Fantastic. 2 weeks, sir.
এটার নামটাই দিলেন,
দিচ্ছি।
নামটা দিয়েছেন, ফ্যানটা দেন।
এত সময় দেওয়া যাবে না।
Item 8.
2 সপ্তাহ।
Item 8, I am appearing for the appeal.
Why is it appearing? Do you know?
Well, I think the paper book is not ready, ma'am.
Well, এটা ওই by an order dated May 7. বাকি সব ঠিক আছে। We are calling for a status report from the department.
Well, we are intending to file a bail application.
Right. File, give the number, it will be listed.
Item 9.
দাও দেখি না একটু টিভি বলছি। issue. By an order dated August 11, 2025, while admitting the appeal, a coordinate bench had called for the trial court records and had directed preparation of paper books within 4 weeks from the date of receipt of trial court records. Paragraph. In the file, we find a note dated October 16, 2025, signed by the Assistant Registrar, Roman 7, to the effect that the TCR has been received and the same is awaiting examination. Paragraph. The department shall file a report before us on the next date as regards the status of the case. Paragraph lists the matter 1 week hence. Shamil Mongolbar.
I saw.
What to call the matter?
Item 10. Passover matter, item number 4.
Item number 4, I am for the appellant, my lord. Appeal admitted, delay condemned, but paper book has not been.
Down. By an order dated April 21, 2025. Coordinate bench covers same. Noted date of registrar and noted date of same. We are calling for a status report. It will be listed again next Tuesday.
Next.
Item 10.
I'm for the appellant, my lord. Admission of appeal, my lord.
Against conviction.
Well.
No delay.
No.
Usual order. The appeal is admitted, etc., etc. Which conviction under which section? NDPS.
Lord, NDPS 20B2C and 29 of NDPS Act.
What is the punishment prescribed?
My lord, 10 years and fine. 10 years and a fine of 1 lakh, my lord.
What was it? Ganja?
Yes, ma'am. 31.68 kg ganja.
So what about the fine amount?
Amount, my lord, 1 lakh, my lord.
Which state? Fine state. This is an appeal against an order of conviction under the relevant provisions of the NDPS Act 1985. Next paragraph, appeal is admitted, etc., etc.
Item 11.
My lord, I am for the appellant. My lord, appeal against conviction in time in form.
Under which section?
My lord, the NDPS 10 years with fine My lord, 31 kgs of gaja.
Only
Clear.
the Chakravarti. You disappoint us.
My lord.
করে দাও সেম আগের অর্ডারটা যা ছিল এক্স্যাক্টলি সেম ইউজুয়াল অর্ডার
My lord. I'm great. নাম দিয়ে দেখো।
Item 12,
So I'm for the appeal. 12 and 13 extra.
12 and 13.
Lordship, 12 I am appearing, 13 my learned
lord,
friend is appearing.
I'm
12
led by
is
Mr. Jana, my lord.
in respect of appellant Moidul Sheikh. Now, Lordship, prosecution case is this: PW1 and 2 and PW3 was the driver. They are on a car going along with their of a jewelry shop, going along with huge amount of jewelry to distribute it in another jewelry shop. On the way, they are intercepted by another car, looted the article. Immediately, PW1 lodges the FIR. Now, charge sheet submitted against 9 accused persons.
Recovery.
I'm coming. I will submit everything. Don't worry. My recovery is 10 pair of earring, 8 finger ring, 1 gold chain. Caesar witness PW 18 and 19 both declare hostile. And I was not identified in TI parade. TI parade you also will find exhibit 9, and I was not identified in court also during trial.
Whether we are hearing appeal right now or bail
No,
application.
bail appeal. So on merit, I am also submitting out
How
of
long
10
you are in
years.
custody? How long-
I am
how
in
long-
custody for more than 6 years.
My lord. Same thing.
You are
I'm for the
13
13, my lord. 13 item 12. I'm appearing for the state in item 12.
and 13
Same case, my lord. 13.
who is for the state.
So why I am submitting on merit? Because Lordship, at the time of arguing of appeal,
If I accept your argument, then we have to see that the conviction was that.
Lordship,
We cannot say so right now.
no, right now your Lordship
whether-
can say that
whether
there are,
the appeal can be heard immediately or not.
or it's an arguable case or not.
Only 6 years.
But Lordship, against me there is nothing not identified. Lordship knows very better than me. 395 case identification is the prime.
They were all wearing masks at the time that the
No, others were identified, not me. Others were identified.
Okay, you are ready. Anything else?
Item number 12, Lordship. So far as the recovery is concerned, Lordship, the Caesar list witnesses, they have proved the signature on the Caesar list. They don't,
They have been declared hostile.
Lordship, only to the extent because they said that the
Take the microphone, sir.
to the point because they said that the Caesar might not have taken place in their
They are
presence.
not
But
identified also.
Lordship, they were all wearing masks. If your Lordship sees the prosecution case when the dacoity took place, everybody had their faces covered, because of which they were not identified.
How could the others be identified?
Lordship, there were two or one individual that got out from the car and fired. That individual was identified. Not from him, from item number 12 appellant, from him there were recovery of stolen items. He did not give an explanation in 313 as to how the articles landed with him. The Caesar list witness do not say that the police made them signed on blank papers or that.
Conviction was when? Conviction was when?
Conviction is of just a minute. Date কোথায় লিখেছি? Just a minute. 20th of September 2023.
Custody trial.
Custody trial. Because there was a recovery, it was custody trial. But those witness declared hostile lordship can peruse the statement of the witnesses. This is the considered. And you
So you are accepting that the witnesses have been declared hostile and they are not identified also.
Lordship, he was not identified. He was not identified.
In test identification parent, TIP.
In the TIP, he was not identified.
Not
The
identified.
circumstance against him is the recovery of the articles. Lordship.
On the day, on the dock, during the time, not even court, not even in court.
The only
How long he is in custody?
more than 6 years.
the
Why
incident
you are
of
telling?
2019. Lordship.
You pray snell cooking, you understand? And there is no chance of early hearing of this application.
Paper books are ready. Your Lordship may fix a date.
Yes, but then appeals of 2019, 2020 are pending. We have to hear them first.
Lordship, so far as the recovery is concerned, there is no explanation in 313 also from as to how he was in possession of the articles. Those articles have been identified by the de facto complainant. The de facto complainant has also preferred a CRAN application before Lordship for return of the articles. So those articles are not disputed.
But the seizure was not proved. How?
Lordship, Caesar list, the signature was proved. Lordship, the witnesses do not they do not
That is
say
an
that.
arguable case. We are not acquitting. We are not acquitting. We are granting bail or not at this stage.
Right? By a judgment and order dated December 20, 2023, passed by the Court of Additional Sessions Judge, First Court, Krishnanagar, Nodia, in Sessions Case number 135-10 of 2020, Sessions Trial number Roman 1, December, 2020, the applicant was actually
You have two applicants.
Only one, Moidul.
Oh, Moidul.
That is true.
Another application is filed by the de facto complainant in my case for return of the seized article.
Lord, I am that filing that application. Lord, I am the owner of the article. The learned judge will specifically directed after conclusion of the trial that the seized article be returned to the actual owner. Lord, I prayed for the return of the goods. Lord, I did not get the sale. So, Lord, I have filed an application before the learned judge also. Lord, the learned judge told that the matter is pending before the High Court. Record is lying with the High Court. As such, I am not able to return this thing. But in the order sheet, the learned judge specifically direct the seized article be returned to the owner of this. Lord, I am praying for return.
After expiry of the period of appeal, then if the appeal is filed, there is an embargo.
There is a bar under
appeal is
452.
pending.
452.
That is a simple law.
Lord,
Now you pay before us, then our senior brother will decide.
Man,
You can direct the concerned of police, concerned judicial magistrate or learned trial judge to consider and.
So since the record is lying here, the predicament with the learned trial court is that learned trial court cannot consider it. The record is lying here.
Whatever it may be, we cannot do this type of. You have to take the Jimanama bond. Or
Yes.
anything.
Yes.
We cannot.
That is that is the whole difficulty.
We shall direct the concerned judicial magistrate or the learned sessions judge to dispose of your application in accordance with law, and pending of this appeal, we will not bar anything that can be done. We shall not take this responsibility.
the
Okay.
learned judge, the learned magistrate found it difficult to pass an order because of pendency of the appeal. We will clarify that this pendency will not stand in the way of the learned magistrate to dispose of your application in accordance with law.
That's all.
We are not passing any positive direction.
And it will be sufficient for you. Please.
Let us first dispose of one application. কি বললাম? The applicant herein এটা আমাকে কি দিলে ভাই? তো অন্য দিয়েছো।
Cran 1, Moidul Sheikh.
এটা ক্র্যান্ড দিয়েছো। ও নিচে আছে ক্র্যান্ড। The applicant was sentenced to suffer rigorous imprisonment for 10 years and to pay fine of rupees 50,000 for commission of offence under section 395 of IPC,
And 412.
as also section 412 of the IPC. Stop. This appeal is directed against that order of conviction. Stop. Paragraph in the appeal, the applicant has filed the present application for suspension of sentence and grant of bail pending disposal of the appeal. Stop. Paragraph. Mr. Chatterjee, comma, look, we haven't forgotten the names. Learned counsel representing the applicant says that allegedly some finger rings and earrings were recovered from the applicant. Stop. Both the Caesar list witnesses were declared hostile. Stop. The applicant was neither identified in TI parade, test identification parade, nor in the dock. Stop. The evidence on record does not support the prosecution case against the applicant. Stop. The applicant is in custody for over 6 years. Stop. Even after conviction, almost 2 years have passed. Stop. There is very little chance of the appeal being heard on an early date. Stop. Hence, the applicant should be granted bail on any condition as this court may deem fit and proper. Paragraph. Opposing the prayer, comma, learned state advocate, Mr. Talukdar, comma, says that the signatures on the Caesar list were identified by the concerned witnesses. Stop. However, comma, it is true that the two witnesses were declared hostile. Stop. It is also correct that the applicant could not be identified since at the time of commission of the offense, he was wearing mask with other accused persons. Stop. The offense is of a grave nature. Stop. No leniency should be shown to the applicant. Paragraph. We have considered the evidence on record. Stop. It cannot be disputed that the two Caesar list witnesses were declared hostile. Stop. It is also not in dispute that the applicant was not identified either in TI parade or in court. Stop. There is also very little chance of an early hearing of this appeal of
2024.
Of 2024. Stop. Appeals of 2019 and onwards are still pending. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case and on an assimilation of the evidence on record, comma, and also keeping in view the period of detention of the applicant in custody and that there is practically no chance of an early hearing of this appeal, comma, we are inclined to allow this application, but on stringent conditions. বলে এই condition আমি দিতাম সহযোগী মনে আছে যখন
10,000 is two stories of 5,000 each. Subject to satisfaction of the landed.
CJM Krishnano.
Same Krishnanagar. And also on condition that he shall not leave any AVE, leave the police station jurisdiction of Chapra. Taken Chapra and shall meet the OC Chapra PS once in a month until further order. Very good. And in the event of violation of any constitution, once in 15 days.
once in 15 days. We clarified the spelling of leave because otherwise LIV would have a different meaning. He shall not leave. ঠিক আছে?
my lord, 13 is relating to other.
আরেকটা ওর সঙ্গে কানেক্টেড অ্যাপ্লিকেশনে যে রিটার্ন অফ
ও হ্যাঁ হ্যাঁ return of return.
I'm not reading my article. In spite of the
It's a grand
specific
one.
direction passed by the learned trial judge. Milord, I'm not getting, Milord, so Milord, kindly,
trial judge has given order
Milord,
in your favor. Then
Milord, the trial judge passed an order.
Sir, show us the order of learned trial judge. Where is it?
Take it, well, then,
Take your application, take CRAN 2.
my lord.
Yes, the similar application.
no, CRAN 2.
Oh, CRAN 2 in the oh, acha, order ta sentencing part.
No, whether that has been made annexure.
Page 70 in your lordship.
My lord, yes.
Page 70.
Page 70 in the CRAN 2.
CRAN 2.
My lord has indicated
Milord, at
subject to expiry of the period of appeal.
Milord, 146
That
page.
is there.
This
Milord,
is the usual order.
My lord,
Because appeal has been filed, that's why magistrate cannot pass such an order without our approval. We are giving this liberty to the learned court.
my lord.
appeal to ঠিক সময় ফাইল হয়ে গেছে তুমি আর কি করে পাবে
Page 17.
70 lordship. 70 of CRAN 2. 70.
That is the part of the judgment.
yes sentence
Last order.
sentence
You can take it over.
paragraph 3 IO is hereby directed to hand over the sentence starts with
Paragraph
3 of the
page number.
my lord page
Page
Yes,
146,
Yes.
running page.
Yes, IO is hereby directed.
yes now it's ends with subject to expiry of the period of appeal.
So after this, any further order was passed by the learned second judge?
Milord, after this, Milord, I
We
made
do not have any idea so far as the trial court is concerned. If the appeal is filed, then the matter will go.
Subject to
That's
expiry of the
sir.
period.
If they do not file any appeal, then you will be entitled
At
to
liberty
take that.
after 60
And
days.
as the appeal is filed, so the guarded judge will follow the order of the appeal court. Okay, we are giving liberty.
CRAN 2 টা করো। This application has been taken out by one Narayan Paul, first title থেকে দেখে নিও, and Kanchon Shaw, comma, for return of the articles seized from the accused persons, comma, claiming that they are the owners of the articles.
Ownership has been proved before the court.
well, because they had collected all these, Milord, the cash memos and
Okay, so the judicial magistrate shall decide the issue in accordance with law.
Paragraph. We find from the judgment and order impugned in this appeal that while disposing of the matter, comma, the learned sessions judge directed the IO, তারপরে quote করো, to hand over the seized gold ornaments to the owner after complying all the legal formalities in accordance with law, comma, but subject to expiry of period of appeal. Stop. Seized gun be confiscated to the government. Stop. ওটা দরকার নেই ওইখানে অ্যাপিল করে সিজ গান দিতে হবে না স্টপ আনকোট করে দেন paragraph. Learned advocate for the applicants says that in spite of such direction, comma, the seized articles in question have not been returned to the applicants. Stop. He says that because of pendency of this appeal, comma, but he has done it session judge has passed direction, তাহলে আর কি করার আছে দেখি
পিরিয়ড অফ যদি পিরিয়ড অফ অ্যাপিলটা যদি অ্যাপিলটা না ফাইল হতো তবে দিতে পারতো
বুঝেছি স্টপ বললাম paragraph. We only clarify that pendency of this appeal per se will not stand in the way of return of the seized articles to the applicants subject to their ownership thereof being established. Stop.
And also on a usual undertaking.
And on usual undertaking. Stop. The learned sessions judge would be at liberty to pass further appropriate orders in that regard, notwithstanding pendency of this appeal.
My lord, this will amount to otherwise directing the learned sessions court to return the articles. Now, my lord, I have taken a point that PW1, who is claiming to be the owner of these ornaments, my lord,
Have you filed any written objection against this can too?
I have against can too. No, I have not, because of the fact that this application itself is not maintained.
You are saying that if they are owner, then he has to decide in
Grant to dispose of. Now your matter, Mr. Johnson.
My lord, so far 13 is concerned, it is relating to other convicts who are standing on the same footing.
It's for the state.
It's for the state. Mr. Undi, is he not in court today?
And Faria.
My lord, the same judgment, same order.
Would be fair. Mr. Nundi may be in personal difficulty, we don't know.
So pass over?
Pass over if you can get him. 13 টা pass over. 12 এ দুটো application disposed of হলো।
Please inform your brother.
Bring him.
রুদ্রবোধের 28 আছে। This is code number 20.
এলে ওটা একটু দিয়ে দেবেন একই রকম অর্ডার হবে।
My lord, in case I am in other court, my learned junior friend will be here. My lord, the same.
If the objection is also same.
Precedential করো 26 এ যাবে
তাহলে স্যার আপনি আছেন
এটা আবার কি হলো দুই আছে কয়েকটা উদু আর সুমন
13টা তো হয়ে গেল ওখানে
13টা
দেখাচ্ছেন
13 একসাথে ছিল বলে দেখি ঠিক করে দিচ্ছি
12 13 দেখিছি একসাথে স্ক্রল টুগেদার আমার 14
Item 14.
I am appearing for the appellant and item number 15 my learned
14 with 15.
But I'm appearing for the other 4 persons, my lord, who are part of the crime.
How many accused?
My lord, in duel, 12 convicted.
No, in item number 14 new.
Yes, I'm 15, I am.
Only for one.
Only one.
Only for one.
Well, let's just see the name in 14.
15. How many?
12 convictions. He's appearing for me, my lord.
Who?
The lordship sees the name satisfies.
Milon listed.
Milon Mead.
Yes. Tell us.
Yes, 14. Same.
State advocates are here.
I am appearing in 14.
Yes.
And you.
Mir Milan. I am appealing for appellant.
You're ready in the matter.
Milan, my lord, it's not in the list, my
Mir Milan is not in the list.
Huh?
My lordship is appealing for another.
No, no, I am in 15.
No, no, sir.
Mir Milan.
Mr. Mukherjee is for full bash, full bash.
Yes, my lord, I am for full wash.
Moharam Mir alias Mir Moharam.
That is your learned friend here.
Think that.
Right. You're ready?
My learned friend is.
I am appealing for Mir Milan.
Mir Milan is not.
It is not in the list.
Where is Mir Milan?
It is not in the list. He is also one of the accused. So, my lord, if your lordship, he is also one of the accused appellants.
He has filed an application for suspension.
Yes.
Let that be listed also then.
Yes, my lord, then keep it on day after tomorrow. my lord.
Yes.
Right.
Give the number.
Can 2 of 25. Well, can it be, my learned friend has some problems with Friday then?
Friday.
Appeal number to leave.
Appeal number to जाओ सब.
Appeal same, grant
Appeal
तो
is
different.
grant Appeal remains same. 33
আমাদের 1 of 24.
14-15 একসঙ্গে মিলিয়ে একটা অর্ডার করো অভিজিৎ ওই যেটা দিলেন ক্রান such and such of 2020 whatever be listed along with these items on Friday date দিয়ে দাও
Sorry. তোরটা সেম হবে না ওর সাথে আমাদের কি তোর অ্যাপিল আলাদা না
গ্র্যান্টটা দেখে
Malad, may I suggest one thing? Malad, Malad, what happened? Sorry, Malad. No, Malad, this appeal, it's a different number altogether.
Yes.
So, Malad, I've asked him to give a slip so that that can come, which has not been listed.
He has filed a separate appeal.
No. It is an offshoot of another appeal.
Whatever it is, give the number.
I'm just giving the number. Sorry. Dide. Friday. Huh?
Mr. Mukherjee, sorry. Friday, this bench will not be there, so keep it on Monday.
Right. On a single.
No, Friday, my learned brother will not be available. It will be a temporary bench with some other.
No point. But we'll miss the wisdom of Justice Sinara.
Exactly.
That is why, Malad, I have asked for Monday.
Monday করে দিও Monday.
আমি 11 থেকে শুরু করব
Monday, 10 তারিখ Monday. 10th, no? Monday? 10th. Grateful, Monday.
Item 16. May it please, Your Lordship. Lord, I will precisely tell Your Lordship what is the matter about, and I will petition Your Lordship to allow my learned junior to address Your Lordship. Lord, there was a charge under section 376, 417 of the Federal Code. 417, there is an order of acquittal. That the lady was 31 years of age.
39 and 41.
30 years of age at the relevant point of time.
What is the age of the victim?
30 years at the relevant point of time.
And you are convicted. How long you are in custody?
Lord, from the 27th of February, I am in custody for about 8 months.
Which was the defector?
So we have
served the copy that has already been received by the defendant.
You are appearing for whom?
He is appearing with me. But nobody is appearing with the victim. Married
Till
now,
date.
appears from the evidence. All possibilities she will not appear.
Acting witness to appear failure. I think.
Yes.
All along.
All on one way.
Yes, it's good.
What is your subject?
The number of occasions promised to marry, taking house into graduation, the number of occasions. I do not have the copy of the deposition.
Why objection was not raised at the first, oh, is the married lady?
You are my child.
No, we are.
Not a married.
That was she was the divorce.
Sorry, not married.
Both the parties are divorced.
Sir, I stand corrected. So is the major lady? She is the major lady. She knows the consequences. So whatever it is, we are not going to.
given the impression that he marries. There was a super ceremony where he was participating. He went to the house of the in-laws. And then it was
If there is chance of abscondence,
Close attendant.
what he is doing? What he is doing? What is the profession?
164 at this stage.
I think.
164 at this stage. Is it a
He was
substantive piece of
he
evidence?
was
Throughout. Wait,
he was
wait.
throughout on bail. He never jumped the condition of bail.
Not at all. Not at all.
बोले, appeal of 25. Appeal of 25.
Appellant is 41.
TCR has recently been received. The department seeks 6 weeks time to file paper book issue. আমরাই অ্যাডমিট করেছিলাম। This bench had admitted the appeal, we find. Nanton নেবে, হ্যাঁ? By a judgment and order dated February 27, 2025, passed by the learned additional sessions judge, 5th court, Howrah, in sessions case number 76 of 2019, the applicant was convicted for commission of offence under section 376(1) of the IPC and was sentenced to undergo rigorous imprisonment for
Acquitted.
undergo rigorous imprisonment for 10 years and to pay fine of rupees 10,000. And 10,000, stop. The applicant has preferred appeal against the same and has filed the instant application for suspension of sentence and grant of bail pending disposal of the appeal. Paragraph. The applicant says that the de facto complainant is a major lady. She's married.
She was a divorcee.
Oh, and is a divorcee. Stop. She, on her own volition, entered into relationship with the applicant. Stop. There was no false promise made by the applicant to the de facto complainant. Stop. In fact, the applicant has been acquitted of the charge under section 417 of the IPC. Stop. The applicant was on bail throughout the trial. Stop. There is no real possibility of an early hearing of the appeal. Stop. Even the paper books are not yet prepared. Stop. The applicant should be granted bail on such condition as this court may deem fit and proper. Paragraph. Opposing the prayer, learned state advocate tells us that the applicant had meted out false promise to marry the de facto complainant. Stop. On that pretext, the applicant entered into physical relationship with the de facto complainant on several occasions. Stop. The evidence on record clearly implicates the applicant. Stop. The medical report also corroborates the prosecution case. Stop. Now, learned advocate strongly opposes the prayer for suspension of sentence and grant of bail. Paragraph. From the affidavit of service filed in court, we find that notice of this application has been received by the de facto complainant. Stop. However, nobody appears for the de facto complainant. Paragraph. We have considered the facts and circumstances of the case. Stop. The victim lady is a major.
Yes.
Stop. How old, how young would she be?
30 years.
Stop. She is about 30 years of age.
Point of time.
She was about 30 years of age at the relevant point of time. Stop. The applicant was all along on bail. Stop. It is nobody's case that the applicant jumped any condition of bail or abused, oblique misused the privilege of bail. Stop. There is also very little possibility of an early hearing of this appeal. Stop. We find from a departmental note dated November 3, 2025 that the TCR has been received by the department, but the paper book is not ready. Stop. The department has asked for 6 weeks' time to prepare the paper books. Paragraph. On an overall consideration of the facts and circumstances of the case and on a prima facie assimilation of the evidence on record, as also considering the fact that the applicant was on bail throughout the trial, we are inclined to allow the applicant's prayer for suspension of sentence and grant of bail.
That was the satisfaction of the learned CJM Howrah.
CJM 10,000 টাকা securities and subject to satisfaction of
CJM Howrah.
CJM Howrah.
Chief Judicial Magistrate House.
Not Sakrail Police Station. Conviction before the additional session judge.
Kanla, what is
Purvodhaman Khalna.
permanently resides at village and post office Krishno.
No, the conviction is that.
Yes,
Kalna.
Kanla, he has to reside on Kanla. He cannot leave Kanla PS and shall meet the OC Kanla PS once in a fortnight. The usual condition.
What the appellant decides? That is all.
That's right.
The department shall department shall prepare requisite number of paper books within 6 weeks from date.
Thank you, sir. Extremely obliged. Extremely obliged.
It's a good day for him. For him, it's a good day because today is his birthday.
Oh, really? Many happy returns.
Thank you so much.
Yes. Stay well, stay healthy, stay happy, stay in peace.
It's a great blessing, sir. Extremely obliged.
You have got the bail order.
Got a bail order. That is what I've said to Mr. Basu. But
Where's the cake? Next.
Item 17.
NDPS?
No, my 302, my lord.
Not Idul Mia.
Not 302, my lord. No eyewitness, my lord. Circumstantial evidence, my lord. PW3 is the, my lord, brother of the victim, my lord. Declared hostile, my lord. PW4 is the
my lord, my lord, daughter of the victim, my lord, they are saying that as per the instruction of the police, she deposed, my lord.
Why is the eyewitness?
There's no eyewitness.
Occurs
My lord, the de facto complainant is the landlord of the deceased as well as the present petitioner. They were staying, they had come to this house only for about a fortnight. The de facto complainant hears hue and cry.
What is the relation between defector?
He's the landlord of the premises. And they are the tenants. On hearing hue and cry, he comes down and finds the appellant crying, and the body of the victim was found in slit throat condition. Others also came. Now, my lord, so far as the minor daughter is concerned, my lord, I don't have the depositions. It appears from the evidence of my lord PW 14, the learned magistrate who recorded the 164 statement, Lordship 96, page 22,
The deposition answer bolo.
that the
Why is the certified copy of deposition?
Deposition is, my lord, with the record, my lord,
The record.
with the LCR, my lord. LCR came before
TCR,
the
TCR,
TCR, my lord.
That, how can it be? How long you are in custody?
My lord, more than 3 years, my lord.
Seeing all these documents.
You see, there's a note dated 5th of July
5th of July.
from the department saying TCR is yet to be received.
So how is it? So show us the from certified
So
copy.
what we can do, we can call for a status report from the department.
Yes, yes, yes.
Keep it on next Tuesday. If the TCR has arrived, we'll call for the TCR from the department.
Yes.
That will have copies of the depositions.
Deposition.
But if it is not received, then
What if the records have not come? Then what do you do?
subject to your lordship's correction, it is not a case for suspension. Some case is made out because in the 164, the daughter says,
take the microphone, madam.
my lord, the daughter says in the 164 that she was in the next room. The father and mother was present. She intended to come and speak to the mother. The father prevented and took out the 2 children to park.
Okay.
When they came back, the body of the mother was found. And the landlord and other tenants, they say, in the intervening period, they have not seen anyone else to enter into that premises. The knife was recovered at the instance of the present petitioner from the kitchen of the tenant premises.
That's 10.
That's 10.
That has been sent to
Human blood matched serological report is there.
Matched?
Well, as human blood
Human blood.
from the bed sheets and everything.
Custody trial?
Yes.
Custody trial, about 3.5 years.
Not a good case for you.
My lord,
Whether we shall wait for the PCR or we shall pass order.
my lord, kindly see the cross-examination of PW4, my lord. Why she stated, my lord? In cross-examination, they stated that, my lord,
All the evidence.
as per the instruction of the police, they deposed before the magistrate as well as before the court.
You are the husband.
Yes.
So somebody killed your wife. Have you lodged any complaint against
My lord,
anybody? I want to know from you. Then why?
My lord,
Somebody killed your wife. Why you have not lodged any complaint?
my lord, on that day, my lord, when I came back from the park, my lord, the landlord lost the complaint. There is no such scope for lodging the complaint, my lord.
We are going to pass the order.
Not this one.
After the hearing, the learned counsel for the Senate and also in the objection of the learned counsel of the state, it appears that there are sufficient incriminating evidence against the present petitioner. Stop. The judgment of conviction and sentence has been passed by the session judge. Considering all the circumstances available on the record, so the petitioner is in custody for about 3 years. Considering the materials on record, we are not inclined to allow the prayer for bail at this stage. But we will do that.
Order till the material record of the gravity of the offense and the privacy of the applicant. That explained. Further, with তারপরে লিখুন we find a departmental note dated July 5, 2025 to the effect that the trial court records have not yet been received by the department, although the same were called for by a coordinate bench by an order dated April 28, 2025 at the time of admission of the appeal. Paragraph, the department shall file a report before us. To be mentioned in the file a report before us on the next date as regards the status of the appeal. And more particularly whether or not the CR has been received by the department. Paragraph, list the appeal under the heading to be mentioned 2 weeks hence. Tarik ta diye dao.
From 18 minutes we appear for the response of union. My lord, the applications are appearing today. Next list.
There are 3 applications in the first appeal, 1 application in the second appeal.
But 1491, my lord, your lordship looking at me.
1491 is the first appeal in the list.
Correct.
There are 3 cans in that application.
My lord, the first, my lord, can, my lord, is my lord stay, for my lord stay. My lord, can 2, my lord, is for my lord. Yes, my lord, is for seeking, my lord, further, my lord, interim order. And can 3, my lord, is order 41, rule 27. So, my lord, 1 is, my lord, with regard to, my lord, the my lord, appeal itself. Because today, my lord, I don't know if your lordships would be taking up the appeal.
Your writ petition has been dismissed.
Yes, my lord, I'll tell your lordship, my lord, what, my lord, the dispute really is. My lord, my client, my lord, is an approved vendor, my lord, of the railways. Now, my lord, it is, my lord, a 50-50 joint venture between an Indian company called Jupiter Wagons and, my lord, Kovis, my lord, of Slovenia. My lord, who are, my lord, very well known, my lord, in, my lord, braking systems. Now, my lord, the plant has been set up, my lord, in India as well. Oh, sorry. My lord, the plant has been set up, my lord, in India as well by, my lord, this joint venture. Now, my lord, my client, my lord, was successful, my lord, in, my lord, several tenders, my lord, issued by the railways, my lord, for, my lord, braking system, my lord, disc. My lord, there is a field trial. My lord, our client's product, my lord, was, my lord, approved. My lord, then there was, my lord, an inspection trial. My lord, there also, my lord, my client's product, my lord, was, my lord, approved. My lord, supplies, my lord, have been made by my client, my lord, in respect of all those tenders. My lord, all the supplies were accepted without any objection and are being used by, my lord, the railways. There is, my lord, no complaint with regard to quality. Now, my lord, suddenly, my lord, several years later, my lord, from, my lord, these tender, my lord, supplies, my lord, we get, my lord, a, my lord, communication from the, my lord, concerned authorities. Please explain the local content and the foreign content in your product. Now, my lord, lordships are aware, my lord, we have, my lord, the Make in India policy today. My lord, for, my lord, local supplies, my lord, which is, my lord, 51%, my lord, of the total content of the product, my lord, has, my lord, a preference. My lord, we had, my lord, over 90%, my lord, of, my lord, the, my lord, content value, my lord, being local. So, my lord, they wanted to know, my lord, how, my lord, what was the local content and what was, my lord, the foreign component. My lord, we indicated that. After that, my lord, we get, my lord, a show cause notice saying, look, the facts which you have disclosed shows that a particular component was manufactured in India, though as per, my lord, the colloquial, my lord, the abbreviated form, my lord, is QAP, Quality Assurance Plan, my lord, revision 2, which was then, my lord, had been issued in favor of my client, required, my lord, a particular product, according to them, to be sourced, my lord, from Covis's plant in Slovenia. Covis being, my lord, also a joint venture partner here. They said, it seems you have approved this, or you have manufactured this in India, which is why your local content is high. And, my lord, we were L1 right through because we are manufacturing it here. We are not, my lord, importing it. No quality complaints. So what they say is, look, your revision 2, you did not source it from Slovenia, from Covis at Slovenia. Therefore, you have violated QAP2. It's a major non-compliance. So you are downgraded. It's in the nature of blacklisting. My lord, 80%, my lord, of, my lord, the tender quantity, my lord, is made available for, my lord, participation for the state largest by, my lord, approved vendors. We are downgrading you from approved vendor list to RDSO list.
To
RDSO approved. Yes, my lord, RDSO development vendor list. My lord, railways design, what's it, SO? Railways research, design and specific organization, my lord, list, which, my lord, only participates for 20%. So naturally, my lord, as far as state largest is concerned, my lord, we, my lord, got, my lord, downgraded. So, my lord, we challenged, my lord, this action. There's a provision for appeal. My lord, to, my lord, the, my lord, the specific authority mentioned, my lord, again, railways. My lord, that appeal, my lord, was also, my lord, ultimately rejected after one round in court because appeal had earlier been disposed of without hearing us. Court said, no, you have to hear them. And, my lord, it was, my lord, disposed of. My lord, again, my lord, we remained, my lord, downgraded. So we filed the writ petition. My lord, that writ petition, my lord, was, my lord, dismissed. Now the short point involved here, my lord, is, my lord, this downgradation which happens my lord, can only happen according to us and on the basis of the terms and conditions, my lord, which are applicable, is, my lord, if there is a deficiency in quality. There is no deficiency in quality, number one, and mere non-compliance in the sense of getting from a different source of a QAP2, my lord, quality assurance plan, my lord, is and cannot be a ground for, my lord, downgrading or blacklisting. Reason being this, my lord, the QAP only, my lord, approves design parameters, not sourcing. And the design, my lord, is indicated, which is a drawing of COVIS bearing a particular number, and which is, my lord, the drawing, my lord, which was followed. There is no dispute, my lord, with regard to that. My lord, when the writ petition was filed, my lord, this was, my lord, the principal ground. And it was also pointed out that all these products have been used and safety is not an issue here at all, because the railways are saying we will not take 80% supplies from you, we will take 20%. So there's nothing wrong with the product. Now, my lord, what happens is the learned judge said that you have violated a contractual term, therefore this downgrading is permissible, number one. And number two, my lord, quality issue is, my lord, not relevant. My lord, where, my lord, it was our, with the greatest of respect, my lord, the learned judge, my lord, had gone wrong, my lord, on this issue. So, my lord, we, my lord, prefer an appeal. My lord, I must show your lordships, my lord, the appellate court order. And, my lord, I must also tell your lordship, during, my lord, the pendency of the writ, there was an interim order, my lord, in my favor, that I'd be allowed to participate in all the tenders as an approved, my lord, vendor. But, my lord, once with the dismissal of the writ, my lord, when I came up, my lord, I asked, my lord, for the self-same interim order. My lord, kindly have a look at
10 September, that was
10
declined.
September, my lord. Kindly have a look at, my lord, that order.
That was declined and direction
Correct.
was given for preparation of informal paper books. That's ready.
Order was expressly rejected by.
Yes. My lord, I
It's
had,
so declined.
yeah, my lord. So this was the position. Now, my lord, what has happened? My lord, result of this has been that, my lord, and this is the subsequent event which I want to bring to your lordship's notice. There have been two, my lord, tenders in between of 3rd of November and 13th of November. My lord, the cut-off date. My lord, I have participated in 3rd, I have put in my bid. 13th, my lord, we still, my lord, have, my lord, time to put in our bid. Now the question is, my lord, what interim order, my lord, can I get considering, my lord, the previous order? I have also pointed out, what is very important is, my lord, I was L1 in all, my lord, the other tenders, where I was allowed to participate only as an RTSO approved vendor. I've been L1 right through, because over and above all this, my lord, what has happened, my lord, is subsequent to this, a quality assurance plan, revision 3, has also been approved in my favor, which, my lord, has given approval to, my lord, this product being sourced from my plant, my lord, in India.
So, Mukerji, once interim order has been declined by a coordinate bench and direction was given for preparation of informal paper books. Informal paper books are ready.
Yes, they're ready, my lord.
We'll hear out the appeal if you like today or day after tomorrow.
Then let me, my lord, kindly start today, my lord. I will.
Not only yesterday, voluminous paper book has been.
There's no volume.
Give us some time for preparation and fix
Day after tomorrow. Tomorrow is holiday.
Yeah.
Yes, my lord.
Come back there.
Yes.
It'll take some time.
My lord, I'll take, my lord, exactly before your lordships. My lord, not more than half an hour to 40 minutes. My lord, there's a Bombay High Court decision, my lord, on a similar issue.
Yeah. Maybe on Friday instead of Thursday.
Mukerji, there is little difficulty. Thursday and Friday, this bench is not available. My brother will not be there. It will be a broken bench, which is of
No.
then Monday.
On next Monday, we shall come back.
then Monday. Hey, Monday কিছু fix করা নেই তো?
My lord,
12:30 p.m.
my lord, just make one prayer. তিনটা তো হবে না, থার্ডটাই খালি। My lord,
তাহলে আর হবে না।
enforcement হয়ে গেছে।
না।
My lord, only this, my lord, problem I have, because the learned judge also, when he took it up, let's say this, I'll be allowing the appeal. Literally, my lord, when I asked for this interim order, my lord, the division bench, my lord, and my lord, this, what happens, my lord, can be of irretrievable injury because the supplies are for 2 years. So, my lord, my lord, even if I succeed, my lord, and they have, my lord, so, my lord, if your lordships, my lord, make some observation, or my lord, I hope, my lord, they will not do anything to render the appeals infructuous. That's all that I'm saying.
What observation?
My lord, wherever I've been declared L1, and my lord, this 3rd and 13 November tenders, my lord, ultimate finalization should not happen till Friday or till Monday.
I oppose to this.
Because otherwise, my lord, they will say,
The interim order was passed.
We will abide by the result of this appeal.
very well, my lord. I'm happy. I'm happy with it.
That in any event that
Yes,
will
but kindly make that clear, my lord, I'll abide by the result.
whether you like it or
Yes.
not, your decision will have to abide by our
And the same
judgment.
thing happened to them also. They obtained an interim order and finally lost.
Issue.
Therefore, they are bound to face the consequences.
Monday 3:30.
Very well.
3:30. This appeal, these appeals. Why two appeals? Why two appeals?
My lord, one is from the downgradation order. My lord, 2 writs were disposed of. And my lord, another is, my lord, from the appellate authority order. My lord, confirming the downgradation. That's why, my lord, there are 2 appeals.
But common order.
Yes, it's a common order.
2
Common
writs were disposed of by a.
Yes.
Correct.
By a
Common order, my lord.
judgment.
These 2 appeals are directed against a judgment and order dated August 26, 2025, whereby a learned judge of this court dismissed 2 writ petitions filed by the appellants herein, being WPA 3234 of 2025 and WPA 14430 of 2025. 3234 is challenging the downgradation.
Yes, that's the first one, my lord.
Downgradation, and the second one, appellate authority.
Appellate.
Paragraph. The appellants say that they are well-known railway vendors. Stop. In connection with a purported dispute raised wrongfully by the railways, the appellants have been downgraded. Stop. Such downgradation, such decision of the railways was challenged by filing WPA 3234 of 2025. Stop. However, prior thereto, the downgradation order was challenged before the statutory appellate authority.
Not statutory, my lord.
Appellate authority, before the appellate authority. Stop. The appellate authority rejected the appeal. Stop. That rejection order was challenged by filing WPA 14430 of 2025. Stop. By the impugned judgment and order, the learned single judge has dismissed both the writ petitions. Paragraph. While admitting the appeal, a coordinate bench, by an order dated September 10, 2025, declined to pass any interim order. Stop. The bench directed preparation of an informal paper book. Stop. We are told that the informal paper book has been prepared.
Yes, my lord, and maybe, my lord, you can
Could I find for this? Hey. Okay, তুমি নিয়ে নেবে informal paper book. হ্যাঁ? Formal তো নয়। তুমি নিয়ে নাও তাহলে। The paper books filed in court today, we kept with the records. Paragraph. Let the two appeals be listed on Monday date, marked 3:30 p.m.
My lord, along with, my lord, can 3, my lord, which is the order 41 rule 20.
That's already there in the list.
Yes, my lord.
The two appeals along with the correct. No, action. Tag করাই আছে তো না? Oh, tag করা নেই. These can be tagged together.
Yes, my lord. Kind.
Tag করে. Let the two appeals along with the connected applications.
And my lord, any steps taken will abide by the.
Paragraph. Needless to say, comma, any steps or decision taken by the railways shall abide by the result of the appeal.
In the pending tenders.
Railways, in connection with the concerned tenders, shall abide by the result of the appeals. Result of these two appeals.
My lord, we were taught, my lord, aim for the sky and you'll hit the tree. The tree also protects.
Correct.
হ্যাঁ এদিকেই চলে রেসপন্ডেন্ট তো আমরা এই দিকটা চলে
I'm finished with the response.
Lord, I appear on behalf of the appellant. One thing, my lord, I should indicate to my lords that this matter, my lord, was heard on a number of occasions by the other division bench. Now, during the course of continuance of the hearing, my lord, a suggestion was given by the court that if the matter can be settled between the parties. Now, my lord, I have taken the instructions on from my clients. The instructions are that he wants to contest the matter. Whatever may be the matter, he wants to obtain a judgment from the court. Therefore, my lord,
You are not also interested in a formal mediation.
No, my lord, there is no question of any mediation. Because why? This is a land and there is a report, my lord, which have been submitted by the government. Now, my lord, your lordships, my lord, has to ascertain as to the quantum of the land which is held by the appellant club in excess of the particular portion which can be given to us. Now, we had specifically made a statement before the before the other division bench that there is a fencing by the club in one part. We are ready to remove the fencing. So far as the excess land is concerned, which is held by the club, we are ready to break down that excess portion. That is all. But now, my lord, the particular respondents, my lord, they want that the particular club has to be shifted in a different place. Now, that, my lord, I had taken a specific instruction because there was a doubt, my lord, in the minds of the client. Once, my lord, they were not indicating specifically whether they want to, my lord, proceed with, my lord, the suggestion given by the court.
owner of the plot of land.
My lord, this plot of land, my lord, was allotted to us by my lord. Kindly come to the paper book.
By the Jela Purishad with the consent of the government of West Bengal.
One second. Mr. Mithru is appearing for?
I am appearing for the petitioner who moved the application. Our grievance was this, that this club has been constructed in the middle of the road.
Nishakar Mondol and Tala Murmu.
Yes.
Yes.
And municipality, Shiuri?
And I am for the response.
You are Shiuri.
Now, my lord, only one document I can show to my lord.
The judgment has been delivered. My lord, saying that the club, the government had no business to allow the club to be constructed in the middle of the road.
Who's the government? Yes. Yes, where are they? What pass over? Shall we hear the appeal today, or what do you want? Because the Chief Justice Shiva Kyanam had directed hearing of the appeal.
Yes, my lord, all the papers are here. Therefore, my lord, and the point is very short as to whether the government could have allowed a club to be constructed in the middle of the road.
I have been added as a respondent in the division bench, not before the single. I could not get a chance to file my opposition. Being a municipality, the talks of settlement was going on. I could not get any chance.
Then he should be granted an opportunity, Mr. Mittal. Because correct, he was added to hear before the division bench.
Very well, I don't know.
His stand is not on record. And also, no. Have you prepared any informal paper book or anything?
All are on record. As my
I think, my lord, because of
senior friend
the
was
Chief
saying,
Justice's order, the matter is being heard on the papers which have been filed already.
These are all on record
Excepting, my lord, the report which has come
from the state government.
from the state government.
The Chief Justice only admitted the appeal, saying that the appeal needs to be heard. There
I
is
see,
no
yes.
observation regarding paper book at all.
Very well, madam.
I
But
leave
if
it to
if you say all the papers are annexed to your stay petition or application for appropriate relief, as the case may be, we'll treat that as an informal paper book and
Yes, sir,
proceed.
absolutely.
In the meantime, we will allow Shiudi municipality to file an affidavit to bring on record its stand. That's all.
Government land.
It was a government. It was a panchayat land, my lord. Initially, with the consent of the Jela Parishad, it was given with the consent
number
from
one.
from the record I am submitting.
Khotiyan
Paper
number
58.
one is
Jela
government
Parishad.
land. Then regarding title of the land, that
Page 58 will dispel it out.
Paper number 1.
Assistant Secretary,
Nice street.
the Assistant Secretary, Panchayat and Panchayat Department, page 58 of the application for stay.
Page of your loss.
That Millard,
Mr.
page
Bhattacharya,
58.
no, we will not go into all these today.
Very well.
Very well. আজকে তো কিছু শুনছি না। এসো। This appeal is directed against a judgment and order dated April 24, 2024, passed by a learned judge of this court in WPA number 8893 of 2020, filed by the respondent numbers 1 and 2 herein. Stop. In effect, the learned single judge allowed the writ petition. Stop. Being aggrieved, the respondent number 7 in the writ petition has come up by way of this appeal. Paragraph. We find from the earlier orders passed by the division bench that
Kindly give the date, my lord.
we find from the find from the order dated May 16, 2024, recorded by a coordinate bench, that the chairman of the Shiudi municipality was directed to be impleaded as a party respondent in this appeal.
He does not have any rule to be.
He has been impleaded.
We find from the memorandum of appeal that the same has been done. Stop. Mr. Chatterjee appears for the chairman of the Shiudi municipality. Stop. He says that since his client has been impleaded in the appeal and was not a party before the learned single judge, he has not had an opportunity to bring on stand his bring on record his stand. Stop. He will be the added respondent will be at liberty to file an affidavit within 10 days. Within 10 days from date, with advance copies to learned advocates for the other parties. Paragraph. We are told that all papers that were available before the learned single judge are available before us. Stop. We shall hear out the appeal treating the pay application as an informal paper book,
along with the report filed by the state government.
along with the report filed by the state government. All formalities are dispensed with since all the parties are represented. From a notice of appeal is deemed to be waived. Paragraph lists the matter a fortnight hence.
Lordship.
And under the appropriate heading.
Well, fairly at the top. Because well, the point is very short as to whether the government could have allotted a land, a part of the road, main road, for the purpose of construction of a
under the heading Group 9, Group Roman 9, bracket hearing, as the first item.
Lordship.
Submissions
Can't
which
get
have,
better than that, Mr. Banerjee. First item.
Hearing gets us very nervous.
the submissions which have now been advanced, Miller, this was not a subject matter of challenge insofar as the petition is concerned. And there are judgments galore which my lords have laid down.
Oh, we shall see.
That, my lord, to what extent the appeal court can, my lord, go into the issues, because Miller court
expand the scope of the writ
yes,
petition.
yes.
Well, I shall confine myself to the judgment, impugn judgment, nothing else.
Very well. Yes, sure.
The judgment says everything.
We'll come back.
Item number 23. Twenty-four. 25.
25, Lordship, I am for the appellant.
Yes, I am for the respondent number 3.
It's an appeal against an order of acquittal in a case of custodial debt.
You are the de facto.
I'm the de facto. I'm not the de facto. I'm de facto died. I'm the brother of the deceased acting as a victim.
I'm representing one of the acquitted.
Who is for the state?
It's a complaint case.
Yes, yes. No, no, GR case. It's a complaint case. Complaint. They are state party.
State is a part of
Which sections? 302.
Not no GR case.
No, it's a complaint case because accused persons are police personnel. So that is why no FIR was registered.
156
156 was moved. It was treated as 200 complaint.
FIR was there.
No, no FIR. Complaint case.
156
Treated as 200.
So therefore, petition as an FIR that was not allowed.
Converted to
complaint. Evidence was taken on oath on an affirmation, and then
that
convicted.
Acquitted. Against an order of acquittal, I have came up.
Private complaint. It's a private complaint.
Private. I am the brother of the deceased.
Paper book ready.
Paper book ready.
Not in 156 strips, directly a 200 complaint.
One note. এটা দুই জাতের one note. Now, Lordship, I am. মধ্যেই আছে যে
Which was the appellant?
I'm
Appellant. The acquittal.
against the order of acquittal.
The de facto complainant.
I'm the brother of the deceased. De facto complainant was my mother. She died during the course of trial. So I'm acting as a
for the de facto complaint. You are for okay. And who is for the accused?
I am for the
representing one of the acquitted.
And
I am for the respondent number 3, my lord.
How many accused persons are there?
Lordship, total three accused persons are there.
3. So 2 are before us. What are
One died.
Oh, number 4 died. Respondent number 4 expired. Yes.
there are three.
Yes.
Respondents. Now start.
State and 2 private respondents. Actually,
Lordship, perhaps in the record, my written note of argument is there.
দেখো
Check it.
So argument.
One of the Dishan.
Huh?
No, which
It was prepared for the previous bench.
yes.
That was the direction. এখানে নেই তাই তো? ঠিক আছে। Okay. Lordship, the prosecution case.
How many witnesses you have accepted?
11 witnesses.
The murder case.
Murder during
11 witnesses.
custody.
11 witnesses.
11.
Doctor has been examined.
Doctor, I will first come to the doctor. Lordship, kindly come to page 29. PW.
It was not, any recent investigation was not done. Okay, only on the basis of evidence of the de facto complaint and his or her witnesses, we have to form opinion whether the accused committed offences or not.
Lordship is absolutely right. Lordship, kindly come to page 29 of the paper.
Pass this jacket.
That one. Sessions. And the additional session judge, fast track court 1, Alipur, South 24 Kolkata. Lordship, actually in this case, record was missing.
Private complaint means that has been submitted before the judicial magistrate.
Judicial magistrate.
And as this is a sessions travel case, which must be transferred to Sessions Court.
Sessions.
Okay. Over how the events you have to show us. Where after solemn affirmation that has been taken. Solemn affirmation.
One day complaint was moved on 10th of July 1996. Lordship, I will provide. Lordship. Let me start subject to correction
Yes,
because
yes, you start, Mr. Chatterjee. It will be helpful if we go through the impugned judgment once.
judgment.
That will give us a bird's eye view of everything, the facts of the
I'm
case.
telling you what the judgment is and what is the prosecution case. Prosecution case is this, that on 29th of March 1995, the victim was apprehended by police personnel. Now on 23rd of March, his family member went to the police station, including independent neighbor. They found that the money was demanded, not paid. Then in their presence, the victim was assaulted by the police person. Since thereafter, whereabouts of the victim was out of record. Now on 8th of April 1995, the victim was first time produced before the learned magistrate in connection with another police case.
Victim was produced.
Victim was
At that time he was alive.
He was alive on 8th of April, and police custody was given till 10th of April 1995 for 3 days. Now surprisingly, on 9th of April, he was again PC return was done on 9th of April. And on 9th of April, the order sheets are exhibited, which you can find from the record. On 9th of April, the learned magistrate found he is physically not capable to stand. And on that score, learned court, without any application for bail being moved, granted him bail or ID to jail. Now, as no one was there on his behalf, so bail bond was not furnished. And on 9th of April 1995, he was straightaway admitted to jail hospital. And on the very next day, on 10th of April 1995, he died at jail hospital. Now,
Postmortem was done.
Postmortem was done, and that is why I am only relying upon the PM doctor's evidence that at page 29, there are 28 injuries PM doctor found.
I was not big. That has been noted. So that's why
And why this acquittal order was passed? Because learned judge rely upon only one document. That the forwarding report, it will exhibit file.
application of custodial death, there must be some judicial inquiries.
No inquiry was done.
Why?
Because all are police personnel.
Whatever it may be that.
No inquiry was ever done.
The accused persons are all police personnel.
All police personnel. LCR, same file.
Because jail is not a place of police officer. Jail
Was
officers are
admitted
different
in
from-
jail hospital, doctors of jail hospital as well as superintendent of jail hospital deposed. Doctors of jail hospital and superintendent of jail hospital were examined. This clearly deposed he was straight away admitted to jail hospital at the time of first production before the jail. He was not treated in the means not entered into the jail compound also. Directly admitted to jail hospital. Now, why the learned judge exhibited nahi bar kore dichhe? Exhibit 16.
as the de facto comment found that there is no scope of filing any FIR because all that accused are police personnel. That's why they have filed a petition.
His FIR, her FIR was not considered. That is why this application was moved before the learned CJM. The Lordship is inquiring about the application. This is the said application.
Well, it was not sent.
And Lordship, surprisingly, the record was found missing from our High Court. Thereafter, High Court directed for reconstruction of record.
Re-examination.
Re-examination, reconstruction, everything was done. Now, Lordship, kindly come to Exhibit 16. Why the learned judge passed an order of acquittal? Because when the victim was first time produced before the court on 8th of April, in the forwarding memo, there is a note, the previous injuries. Previous. Old injuries. Exhibit 16. Lordship, kindly see, old injuries, it was written in the forwarding report. Now, if your Lordship kindly see the order, Exhibit 15, the order passed by the learned magistrate on 9th of April, it is clear when he was produced in court, his physical condition was so deteriorated without any application being made. Moved.
Why the magistrate did not take any steps on production?
Will you kindly come see Exhibit 15.
Violation of Supreme Court order.
Kindly see Exhibit 15. No, if your Lordship sees,
I'm sure. I want to go through that.
Lordship kindly appreciates one aspect. Whatever has been submitted by my learned senior friend, this complaint came to be lodged 1 year after the incident. 1 year after the incident. And your Lordship's first query was, why was not any steps taken for sending this complaint as or for filing any 156(3) or something like that? No such thing was done. Apparently, there were 2 alleged eyewitnesses. None of them came forward with anything for a period of 1 year. They are alleging custodial torture.
After the production from Kishi, the judicial magistrate found that he sustained severe.
Yes, regarding that,
So
on the first aspect, the victim, he was conscious. On the second day, he was conscious. Did he complain himself about anything regarding custodial torture? The post-mortem report, yes, the post-mortem report speaks about as many as 28 injuries. He was also examined prior to that by another doctor.
We explain that sustained by the victim, the concerned police officer.
Whether those injuries were sustained in our custody or not, Lordship, PM report will only prove about homicidal death.
Before sending to the correctional home,
yes,
judicial magistrate recorded that there are 28 injuries of
no, it was not recorded by the
28 sufficient injuries on he found on the body of the victim after production from PC. That is sufficient. I have to go to
yes.
record.
It was only recorded that he is not in a position to stand. Nothing has been recorded about custodial torture, your Lordship. And another aspect, once he was produced, in every production, accused is represented by an accused.
Why he was taken to custody?
In connection with a criminal case, Lordship.
No, under which section?
Under which section? That is
just wait for 2 days or 3 days. You see,
yes.
Before completion of that period, the police officer produced. Is it correct?
Yes. So, but on the first day, no, certainly, because since
the complainant was an illiterate lady.
Lordship, for 1 year she is not coming out, and now they are seeking to reverse an order of acquittal, where the complaint itself has been lodged after. No, we have been acquitted. We have been acquitted. But Lordship kindly appreciates the presumption of innocence strengthens further once an order of acquittal is passed. This has been laid down by the Honorable Supreme Court. The complaint has been lodged after 1 year.
Time to go through the record.
No, certainly not. Because since Mr. Chatterjee has based an overview of the case,
first time I am
LCR, TCR,
My detailed
TCR,
lordship filed in the record.
TCR tax.
We have not yet filed, but during we are yet to file because it has been heard by the division bench presided over by my Lord Justice Boshak on.
Okay.
was not
Now
filed.
my written note in the record.
Does it go through whether the trial court has rightly
But they
Yes,
can
certainly.
try.
I have my
They-
submissions to
they-
make.
people will practice it.
Let my learned senior friend
Now
confirm.
they
Then
don't feel for the whatever.
এইটা কার record part? But I shall get this all this document.
This is LC exhibit file.
it's the second file.
This is my written notes is there. Lordship will find the exhibit serial number I have given.
Major
The serial number I have given everything.
This list of dates is also your written note.
Lordship, list of date, exhibit list, and witness list and status.
Very well. We'll keep it on Friday week.
Friday.
Next week, Friday. All right. Dekhe now. Heard learned counsel. Heard learned counsel for the party. Learned counsel for the parties. Briefly apprise us of their respective cases. Paragraph lists this matter once again on Friday week as the first item under the heading, key heading criminal appeal bracket here, criminal appeal hearing. First item under the heading criminal appeal. It will help everybody if we do some homework and come back.
My Lordship, I am led by the Shantanu Talukdar. He will be not present in the court for next week. Please
All
kindly.
of next week he will not be there. Very well. Monday week.
Monday week it's 17.
Any problem?
Can it be on 18?
18.
I'm deeply
Obliged.
I'm grateful.
মনে করে বাড়ি তো which part is
So Oroni Bhattacharya, yeah, my lord. But kindly fix up any date, my lord, then we will finish. My lord, the case is based on.
What do you, yes?
Lordship, Mr. Shur is appearing for the state lordship.
Yes.
Yes, Mr. Shur is appearing for the state lordship. Kindly fixes up a date lordship.
What fix up? This fixing thing doesn't work. We are here. If today you can't do it, then we'll just say not today.
Not today.
It will retain its position wherever it is.
Very well. Yes, lordship. Grateful.
27.
উত্তরে পাইনি আমি দেখি এই যুদ্ধ দিক থেকে পাইনি Yes, 27.
And for the state, there is an application for relaxation of condition of bail which was filed. Lord, I have been allotted that brief, and so far as the paper book is concerned, Mr. Joydeep Roy has been allotted.
No, but the
Lord, I stand corrected.
appellant
Joydeep.
is not there.
Yes, Lord.
Passover or not today, whatever.
Lord,
Passover for
Joydeep makes it not today.
not today.
Great.
Lekho to, the appellant is not represented. Paragraph on the request made by learned state counsel, comma, let this matter stand adjourned for the day.
Great.
The relaxation application is appearing in the list.
Yes, Lord. It's CRAN 3.
CRAN 3, yes. Achhe to tumhar record hai CRAN 3. Bail granted by the division bench.
Item 28. 29.
I'm appealing for the state, led by Mr. Nonti.
And for the appellants, my lord, I'm led by Mr. Udashankar Chattopadhyay.
My lord, I have prepared two written notes, my lord.
Will you argue the matter?
My lord, I'm ready to proceed with the case, my lord. In the meantime, Mr. Chattopadhyay will join.
Victim service করেছিস but the case of 376D the victim should be served before hearing the appeal.
Victim has not been served.
376D matter is a conviction for
Gang rape.
20 years. Yes, yes, gang rape.
Victim should not serve.
No, my lord, no.
No, serve. Hey, देखो. Or why don't you serve? The appellants have been convicted for commission of offence under section 376 D, capital D of the IPC. Stop. We are of the view that the victims should be served. We have the view that notice of this appeal should be served on the victims. Paragraph. Let the state serve notice of this appeal on the victims and file a service report on the next date. Paragraph. How many victims?
My lord.
What?
Victim only one, my lord, and accused persons two.
One. So when shall we keep it? 10 days.
Puru Bardhaman, my lord.
Next week, someday. Next week. List the matter once again. Next Tuesday, next Tuesday to Tuesday date. Comma retaining its position.
My lord, the written notes will be.
Paragraph. Written notes of argument filed on behalf of the appellants. Two appellants,
My lord.
on behalf of the appellants be kept with the record.
Item 30.
My lord, I am for the appellant.
Item 30, Shuri is appearing and being for notary.
On the prayer, on the prayer made on behalf of the state, capital S, comma, let this matter stand adjourned for the day. Appearance name now, Mr. Jana appear in an appearance name.
My lord, it will retain his position.
Yes.
My lord.
Hey,
Mr.
Tarunambur.
Nondi is.
I'm sorry, madam.
No, I told him they will have to call.
Mr. Nundi, we have granted bail upon suspension of sentence in number 12.
Item 30.
So if it's on same footing, then
Only difference is perhaps TI per identification.
Yes.
identified.
Yes, they are identified in the TI parade. But my lord, so far other things, other points are concerned, it remains the same. Caesar lead witnesses are concerned, they remain the same. More fully, PW 13, 19, 17, 18. 17, 18 is more specific in saying that we have signed the document while sitting in the tea stall, and other said I have signed in a blank. That is the whole thing, and my lord, for 6 years they are in country. Out of 10 years. Term imprisonment of 10 years.
Otherwise, 10 years term imprisonment.
10 years, yes. I'm really thankful.
10 years already.
Already we have under.
That's why I said, the only difference is.
No, we are.
That's the only difference.
Not actively.
No, I leave it to your lordship.
I'm
Lordship has asked me. That's why I said.
I'm extremely
That's the only difference.
And I'm thankful to Mr. Nandi. Grateful to your lordship.
It's a term imprisonment.
Yes, a term.
এসো ও বাবা কেমন আছো অনেকদিন বাদে দেখো দাঁড়িয়ে রেখেছো
Everybody is following your lord. except me, because I am not that handsome.
Absence of deduction. By a judgment and order dated December 20, 2023, passed by the learned additional sessions judge, first court, Krishnanagar, Nodia, in sessions case number 135, bracket 10, bracket close of 2020, sessions trial number Roman 1, bracketed December, bracket close 2020, the present applicants along with other accused persons were sentenced to suffer rigorous imprisonment for 10 years and to pay a fine of rupees 50,000 each for commission of offence under section 395 of IPC, as also under section 412 thereof.
Resident of Chapra.
Chapra. Nodia Chapra. Mr. Das's case.
They will again commit different.
No, no, my lord, kindly.
What, we injunct them from committing the question?
My lord, that is the whole thing that can be done, but it's impossible to do.
Can put a condition
Well, look at meeting yes. We shall be meeting the IO.
There's only one appeal filed by all
No,
the
there are two appeals, one by Mr. Chatterjee and this one by the other five.
The applicants have filed an appeal challenging, he said, conviction order, and in the appeal has filed the present application for suspension of sentence and grant of bail pending disposal of the appeal. Paragraph. Learned that Mr. Jana, learned senior counsel representing counsel.
Only counsel.
We have not said senior advocate. We have said senior counsel. Senior counsel appearing for the applicants says that the both the Caesar list witnesses were declared hostile.
All six.
Huh?
There are 6 Caesar list witnesses. All are declared hostile.
All the 6 Caesar list witnesses were declared hostile. The applicants have been in custody for more than 6 years. There is very little possibility of hearing of the appeal on an early date. Paper books have been filed.
Paper books are
right. Appeal of 24. 24. Almost 2 years have elapsed from the date of conviction. The evidence on record would not support the prosecution case against the applicants. The applicants should be granted bail on such conditions as this court may deem fit and proper. Paragraph. Opposing the prayer, Mr. Nondi, learned senior counsel representing the state, says that the applicants were identified in test identification parade. There was recovery of the jewelry, the looted jewelry from the applicants. There is sufficient material on record to uphold the conviction of the applicants. Stop. Mr. Nondi strongly opposes the prayer for bail. Paragraph. We have considered the rival contentions of the parties. Paragraph. We have gone through the available material. Stop. We see that although 2 years have elapsed since the appeal has been filed, the appeal has not been heard. Stop. In fact, appeals of 2019 onwards are still pending. Stop. There is very little chance of this appeal being heard on an early date. Stop. The applicants have been in custody for more than 6 years. Custody trial. Trial. Stop. Yeah. Paragraph. On an overall consideration of the facts and circumstances of the case and on a prima facie assimilation of the material on record, we are of the view that we are inclined to allow this application. But on stringent conditions, করে item number 12 এ দেখবে যে condition গুলো আছে।
Only one thing, two more things which I
as condition.
One is that meeting with the officer in charge, but to restrain them and to provide their phone numbers to keep a track on them.
Yes.
To give an undertaking.
Existing phone number.
Yes, ma'am.
They will change this thing.
They will not change. That should be the direction of the court.
And report once every 15 days. Phone number টা দিয়ে দেন, শোনো তাহলে 12 নম্বরেও বলো phone number টা কোথায়।
Without leave, they will not change the phone number. Yes.
Without leave of the okay.
We can track him to the phone, my lord. Because if they provide, we can get their location.
They will not.
Without whose leave?
Without this court's leave.
Without the trial court.
The change of the SIM, but there is no injunction, my lord, in buying a new SIM.
No, I'm not. You will provide the.
I understand.
Why, my lord?
I understand.
These are dacoits.
Keep their phone number.
These are dacoits.
I understand.
Do not change with the permission of the Mr. Vidroditanu.
The applicants will furnish their mobile phone number to whom? To
the court.
To us.
If they want to change this in they or again.
Yes, they will.
That's the business.
But these are my lord, technologies are helpful to prevent.
Officer in charge.
To the officer in charge of the concerned.
Krishnanagar police.
Don't say concern.
Chapra police.
Chapra police station.
Shall meet you in Chapra police station. Once in a couple.
না ওটা তো আগের থেকে বলেছি ওই আগের থেকে দেখে বুঝেছো 12 নম্বর থেকে
ফোন নাম্বারটা
এই ফোন নাম্বারটা খালি 12তেও ঢুকিয়ে দেবে সব in the event they change their telephone number they will keep the police informed এটা ওটা ঢুকিয়ে দেবে
I'm extremely
Item 31.
My lord, item 31, my lord, in respect of CRA TB 71 of 2023. My lord,
your brother is not here.
এই স্টেটের কি আছে 31 এ
31 এ আমি নই 32
স্টেটে কি আছে
Pass over, find out, bring him.
My lord, no, what happened, my lord? That one appeal, my lord, I am appealing for the appellant and I am appointed by the High Court Legal Services Authority. And my lord, another appeal, my learned friend is appearing for Sushanto Malla, that is CRA DB 226 of 2020. My lord, the paperwork, my lord, I have received just few days back. So, my lord, I need some time. That's why.
We'll give you time. Why you look so worried? We'll give you time. What is the section under which you have?
300.
My lord, as regards to CRDB 226, if the state is present, let my partly submission be recorded. That is.
Why you want to do it piecemeal, sir? Your friend wants some time. You will make submission today. By the time your friend comes back, we'll forget what you have said. So do it all together because it's the same co-accused person, same case. देखो 31 আর 32 সরি 31ই তোমার দুটো আছে দেখবে 71 আর 26 learned advocate for the state is not present in CRA DB 71 of 2023. Paragraph.
And 2026.
Learned advocate for the appellant in CRA DB 71 of 2023 seeks a little time to get better prepared.
Fine.
Next week.
Yes.
Paragraph. List these matters once again next Wednesday.
My lord, kindly mention CRD, learned advocate for the CRD 2026 is present.
Your appearance will be recorded. Give your appearance. Okay, Koro. You practiced in Calcutta? Amongst the first five items under the heading Criminal Appeal Hearing. শোনো পণ্ডিত
বারো
বলে দিও দুটো স্যানিটাইজ
And for the street.
33.
Lordship, Mr. Nondi is appearing, Lordship, and praying for not today, Lordship. I shall inform, Lordship.
Fixed any date, my lord.
We can't fix any. Accommodation is prayed for on behalf of the state. Paragraph. Let this matter be listed once again on Monday date now, amongst the first five items under the heading Criminal Appeal Hearing. What is the nature of charge?
The 302. My lord, very short matter within 10 minutes.
Very well. Please inform Mr. Nondi, please don't take time on Monday. You're assisting him.
I'm not there in the matter. Miss Shonali Das is appearing in the
Anyway,
matter.
somebody should be ready, prepared for the state.
35, 34, 34 to 37.
My lord, item number 36, my lord, Mr. Basu is appearing for one of the appellants, my lord. Would it be your lordship's pleasure to take it up after 11th, my lord?
In 36, he is appearing
36, only 36 is appearing
for the appellant.
for the appellant.
Request is made on behalf of learned senior counsel representing the appellant in CRA DB 105 of 2023 for taking up these matters after November 11, 2025. Paragraph lists these matters once again on November 13.
Thirty-eight, nine,
For the state lordship.
Yes.
Yes.
Conviction is under section 302 IPC.
Yes.
The allegation was, my lord, the lady was set on fire. The allegation was that, and she was 100% burnt. And after 7 days, she passed away.
Dying declaration,
No, my lord. She was alive for 7 days after the incident.
100% burn. How he can speak?
There was,
How were you related to the victim?
my lord, I'm the husband. Oh, I am. No, my lord, I am the sister-in-law. I'm the sister-in-law.
Your allegation is that sister-in-law poured kerosene oil upon her.
So you're ready to argue your case.
My lord, I can start.
No question of starting. If you start, you have to end, conclude.
Who is leading you?
Then, my lord, kindly fix a date for.
Tell us when.
Sorry.
You tell us when.
Next week, my lord.
Accommodation is paid for on behalf of the appellant. So, paragraph lists this matter once again on November 14.
How long you are in custody?
More than 5 years,
Custody trial.
my lord.
How many accused?
There was 2 accused, my lord. One has been acquitted. I am being
Who was
convicted.
acquitted?
My husband.
Your husband.
Husband of the victim?
My lord?
Husband of the victim was
No, my lord.
It's not.
No.
was not
There's
an
the brother-in-law and the sister-in-law.
Okay.
And place of occurrence was where?
In the house, my lord, where they were residing.
Whose house?
This is a joint property, my lord.
Joint property.
Yes, my lord. That was not partition, but they were living in separate place, but in the same house.
Right. Come back prepared.
Great.
Do you have a leader or you will argue?
My lord?
Do you have a senior in this
No, my
matter?
lord, I will argue.
Please, please.
forty, 41,
Lordship, I'm appearing for the appellant.
before the state.
The learned public prosecutor sir is appearing, lordship.
Who?
I shall inform lordship. The learned public prosecutor sir is
Public
appearing, lordship. I shall inform lordship. Kindly make it note today, lordship. I shall inform lordship.
Accommodation is paid for on behalf of the state. Paragraph, list this matter once again on PROCEEDINGS. Thursday is all right for you?
Thursday is fine.
Huh? Oh, no, sorry. No. My brother will not be there. Monday.
Next week then, my lord.
Monday.
Monday.
Date the amongst the first 10 items. Amongst the first 10 items under the heading Criminal Appeal Hearing.
Obliged.
Lord, I am for the appellate, my lord, led by Mr. Mondal, my lord. I am praying for 2 weeks' time, my lord, for hearing, my lord. Not any date after 2 weeks, my lord.
Learned advocate for the appellants seeks 2 weeks' time. Stop. Paragraph, list this matter once again. On November 19.
Deeply obliged, my lord.
Kothai, 42.
43.
I am for the appellant, my lord. My lord, praying for 1 week accommodation, my lord.
Appellant.
Yes, my lord.
Learned advocate for the appellants seeks a week's accommodation. Paragraph, list the matter once again on November 11.
My lord, I am for the appellant. My lord, out of 10 years, I am in custody for 8 years. My lord,
NDPS.
NDPS. My lord, written notes are there, filed with the record. My lord, we both have filed the written notes on the on earlier occasion. My lord, only a small point is involved.
Brand 2 is your suspension.
Suspension.
8 years out of 10 years.
Nigeria. My lord, I am a Nigerian. I am a Nigerian. My lord, I was arrested with allegedly 100 grams of cocaine. My lord, I have my brother in India. My lord, I am
Section 37, section 37 will come into play.
Section 30 because cocaine, it was 170 grams required.
That is that if we can grant bail.
Yes.
Not this bench. I am saying that in respect of 439 case, you can grant bail if find that he cannot be convicted.
Yes.
No, you are convicted here.
Yes.
So then how
My lord, the sole point of conviction is bad in law. That is because, my lord,
we have to hear the
gazetted officer acted as a part of the raiding team.
Mr. Chakravarti, we'll fix this appeal at the top and hear it out.
My lord, because I have served out, my lord.
We are ready.
My lord, we both are ready.
Monday or Tuesday.
What is the term of imprisonment?
Because
10 years.
10 years, it has been awarded. My lord, I am in custody for more than 8 years.
Only 2 years.
My lord?
Only 2 years.
Yes, my lord, I am in custody for more than 8 years. Plan 2 is the
The
suspension.
appellant has been convicted under sections 20.
My lord, 21C of the NDPS Act.
21 capital C.
Bracket
Bracket
C.
choto C of the NDPS Act of 1985. Stop. Here he was sentenced to suffer 10 years rigorous
Yes,
imprisonment.
my lord. And to pay a fine of rupees 1 lakh with a default clause.
And pay a fine of rupees 1 lakh with a default clause. Stop. Paragraph. Learned advocate for the appellant says that the appellant has already been in custody for 10 years.
No, my lord.
8 years.
Since 5th January 2018.
Since January 5.
2018.
2018. Stop.
No.
He paid for suspension of sentence and grant of bail, pending disposal of the appeal. paragraph, Mr. Bhattacharya, from a learned advocate representing the Union of India, points out that the appellant is a Nigerian national. Stop. There is every possibility of the appellant vanishing if he is enlarged on bail. Paragraph. We shall hear out the appeal, giving its precedence. Stop lists the appeal under the heading Criminal Appeal Hearing amongst the first 5 items on Tuesday.
No, tell me, your possession has been proved from. So
Well,
you have to.
Possession is proved. My lord, I am covered.
Pardon of proof.
My lord, I am.
Possession has been proved.
My lord, I am covered.
On technical ground.
My lord,
That is my question.
my lord, I am covered by Paramananda. Because when gazetted officer acts as a part of the.
Consider. You answer my question.
My lord.
Your possession has been proved.
170 grams.
This is the reverse burden of proof.
My lord,
Come back with the proper answer.
my lord, in Paramananda, the appellant was acquitted because though it was found from his possession.
No, you are only on the basis of
only on that Paramananda. Because my lord,
Boy is always dynamic.
My lord,
Boy is always dynamic.
my lord.
Boy is always dynamic.
Yes, Lord. My lord, we are learning from.
330, she has never ever felt any issue of prejudice.
My lord, that
He
will
was
be.
shocked to see the cross-examination.
My lord,
At least there should have been some suggestion
my lord, in chief.
that because of inaction or purported inaction, I suffered prejudice. That has
My lord,
that should have been there.
313, your lordship knows how it is done. Only yes, only no. And my lord, in Paramananda, it has been held that if someone leads the raiding team, he cannot act as a gazetted officer.
Hey.
মঙ্গলবার প্রথম 5টা করে
among the first 5 items.
I'm grateful.
11.
My lord, we are so elated to see your lordships back with us.
Thank
Grateful
you.
to your lordships.
45.
45, there is a co-accused also who has also preferred an appeal. My lord, I am appearing in that matter. It's CRA DB number 285 of 2020.
লিখে নাও যেটা বলছেন উনি।
CRA DB 285 of 2023. Wasid Momin versus State of West Bengal.
এবারে তুমি একটু অর্ডার করো। Nobody appears for the parties. Paragraph. Learned advocate appearing for the learned. We are told by Miss such and such, naamta diye debe, learned advocate, that her client has also filed an appeal from the same judgment, being CRADB, ওই যেটা বললেন। Let that appeal be listed along with this appeal on November 13.
Six. 47. 48.
In this matter, lordship, we are appearing, and our matter was running in the list, but due to some fault, our matter is not in this list. So this matter may be listed.
Give.
Lordship.
I have been item number 8.
Let যেটা দিল নিয়ে নাও।
Here are 3 criminal revision. Only one is criminal appeals.
Matter, second. This matter is bail in connection with appeal. They are in incarceration for about 18 years. So
18 years in
18
custody.
years.
এই শুনছো?
Bail in connection with appeal.
Bail in connection with appeal, এগুলো মাথা ঘামাও একটু। 18 বছর জেলে আছে।
Asmira Singh will lie here.
Custodial trial was held by.
Give the CRAN numbers. Give the CRAN numbers.
The CRAN number.
In item number 48,
One.
there is scan. There is scan.
Tran one, Tran one.
Can one.
Tran one.
TN2 and 364. TN2 of. In item number 48, my lord, there is scan application.
There are 3 appeals. How many appeals?
3 appeals.
In each appeal there is a CRAN.
Yes.
Yes.
ওই অন্য দুটো অ্যাপিলের নাম্বার দিয়েছিল নি?
Yes.
তাহলে লেট such and such, CRA such and such. ইয়ে ফাইল আছে? একটা ফাইল আছে।
এক সঙ্গে ট্যাগ ছিল, সবাই ছিল তো, লিস্টে ছিল, রান করো।
Let CRA such and CRA such and such be listed along with this matter and all connected applications. Monday. ডেটটা দাও। শোনো, এগুলো অ্যাপ্লিকেশনে দেবে, এগুলো অ্যাপিলে ঢুকিও না। কারণ ক্র্যান যেখানেই ক্র্যান থাকবে অ্যাপ্লিকেশনে দেবে।
Hmm.
হ্যাঁ, actually. Under the heading বললাম কি? Under the heading? Under the heading application, sir.
Sir.
And 49 with 50.
Lordship 49, my lord. My lord, 49 and 50, they arise out of the same self-same judgment and order of conviction. Now, Lordship kindly takes up page 82 of the paper book. There were 3 persons who were convicted. I have been engaged by the High Court Legal Services to represent one of the convicts, Abdul Rashid, that is item number 50. Ainul Hussain is in item number 49. Now, insofar as the other convict is concerned, Shahnawaz Akhtar, a report may be called for whether he has preferred any appeal or not. Otherwise, these 2 matters may be.
And who is appearing for Ainul Hussain?
Lordship, I'm led by Mr. Joy Chakraborty, my lord. I prefer not to them. If your lordship kindly takes this matter next Wednesday or Thursday.
We'll call for a report. Learned advocate for the appellant in 4950 action report. In CRADB 110 of 2022 tells us that there was a third convict in this case by the name of
Shahnawaz Akhtar.
Shahnawaz Akhtar.
Page 82 of the paper book.
Page 82 of the paper book. So, paragraph, we'll call for a report from the department. From where?
Yes, yes.
Let the department file a report before us as regards whether or not the said Shahnawaz Akhtar has filed any appeal against the judgment and order which is under challenge in these 2 appeals. Paragraph lists the matters once again on Mongolbar.
Next Wednesday or Thursday.
Next Wednesday. Wednesday under the heading to be mentioned. Let us first find out.
Grateful.
Fifty-one with 52.
Lordship, item 51, I am for the appellant, my lord. I prefer not to.
Learned advocate for the appellants in CRADB 223 of 2024. Its accommodation for the day. Paragraph, let the matters stand adjourned for the day. Let these matters. হয়ে গেল। কতবার আছে?
Second call, item 23.
Nobody appears for the appellant oblique state even in the second call, paragraph. Let the matter be listed again on November 18. Nobody appears for the Union of India even in the second call, the same করে দাও।
Twenty-eight.
28, Lordship, I am appearing on behalf of the appellant. In 28, I am appearing. I have a written notes. If Lordship will allow, I will argue the case.
Who is on your other side, state?
Yes, so we take time.
I'll
Except
inform
not
him.
to,
Who?
Mr. Rudradikan only.
not to.
When should we keep it?
But not today. I'll inform him, my lord. Let
No, then not today. We'll keep it next week.
Fine.
As your Lordship.
Accommodation is paid for on behalf of the state. Paragraph lists this matter once again on November 12th.
Obliged.
Item 32.
Nobody appears for the appellants even in the second call. Paragraph lists the matter once again on November 19.
Item 38.
This matter, Lordship, I am appearing. I have a written notes. I can argue this case.
Go for the state. You come back at 2 p.m. You ready? You are ready.
Yes, yes.
Then 2 p.m. we'll take it up.
2 p.m. Yes, Lordship. As your Lordship. Or make it not today. Not today.
Not today.
It will take long time.
How long?
At least 2 hours.
Why?
At least 2 hours.
Why? What is the charge?
38 witnesses, murder case. 38 witnesses. So not
Today only we have some time. So come,
Only
better
not-
come and argue.
only
You have come at 2 p.m.
2 p.m. is all right for you.
And it was detected that the nylon rope was over the neck of the dead body.
Which area was this?
The Tupukur area.
Dead body was found.
Yes, in the garden. In the garden.
Whose garden?
That in that locality of the Tupukur area. And the case has been started against unknown. Subsequently, on the basis of the information given by the van puller that I have heard Rabin was talking with Sunny deceased. Rabin is the accused in this case, and the person who died, his name is Sunny. And he deposed in the court that I have heard his talking during the conversation.
Speaking.
Yes, talking. He was talking with each other.
Robin and Sunny.
Yes,
And it was heard by
the van puller. And van puller was absolutely unknown to them. No TI was held. Test identification period was not held. It is well settled law that if the person is unknown and TIP was not held, evidence is valueless. As because he is not known to them, and in the court, yes, I know him. The Honorable Apex Court appreciated this aspect in a landmark judgment, Gangaram Singh Ghyani versus State of Maharashtra.
citation.
Gangaram Ghyani versus State of Maharashtra. The Honorable Apex Court held if the person first time identified the accused in the dock and no TIP was held.
What is the citation?
Gangaram Ghyani.
Yes.
I'll give lots. I'll give lots. And another circumstances is last seen together. Those employees who were standing in the platform of Barakpur, and he deposed that in the running train, he saw Rabin Singh was in train or going to catch the train along with the Sunny deceased. In a running train, he was able to see. And Lordship, I will come on the point. So before starting my case, I beg to draw the kind attention of this Honorable Court, a landmark judgment, and the popularly known as the Sarda case.
Viddichar.
Yes, Lordship.
Sarda Viddichar.
Sarda versus State of Maharashtra, 1984, Volume 4, SCC, page number 116. The relevant para is 114, 115, and the 116. The Honorable larger bench of this Apex Court in a locus classicus judgment held that, however the suspicion grave it may be, it cannot take the place of legal evidence. And if the entire case hinges on the circumstantial evidence, it is the obligation on the part of the court. Be careful. If there are two views, one goes in favor of the accused, another goes against of the accused, court must accept those views which are in favor of the accused. Another impressive line is that the higher degree of offense, the stricter degree of proof is required to convict the accused. But in this case, the prosecution examined total 36 witnesses. And all witnesses are saying that I have heard, I have not seen the offense. And initially, the case is started from love triangle. There is a love triangle in this case. Robin Singh was loving with a lady, and the deceased was also in love with the same lady, and the one Rupak is also in love with the same lady. All are young person.
So Rupak was examined as a witness.
Yes, yes. I beg to draw the kind attention at page number 29, Momita.
You carry on your.
Yes, Lordship. So, Lordship,
No direct evidence.
yes, Lordship, no direct evidence. Two major circumstances are: one is last seen together in a local train.
What is your explanation?
My explanation is, Lordship,
You had seen the last together in a train. What is
last seen together.
the false evidence? You have said.
Consistently, our Honorable High Court as well as the Apex Court is a weak type of evidence. In a local train, he was catching the train. How can he see? There are so many persons, so many passengers.
We can see when a train passes through a platform. We can
Like Sialda
these
station,
persons are there.
Barakpur station, if there are so many persons.
Not that. No. That is different too. Whether we shall believe his testimony or not, that will.
Lordship.
We can see.
No, I am the employee in a hotel. I was discharging my duty at that point of time. And all these are afterthought. They have no such explanation in the FIR. After due deliberation and after
Sometimes accused killed a person without any presence of
and Lordship.
without the presence of any witness. He
And
committed the crime.
another point is that Sunny is a young man, and the allegation is that in the postmortem, in the several witnesses, this person is the only
What?
Robin Singh. Robin Singh, if a person is alone and if a young man is there and he would kill him with the help of nylon rope, stiffest resistance is bound to occur, my lord, as because he is also a young man and nylon rope in his neck and he is alone. He is the only accused in this case.
We have to see whether if the nylon rope has been used, whether it has been used from the backside of the victim. Can be.
Lordship, if from the backside,
So we have to go through the
I
postmortem
can
report.
explain, Lordship. If he is a young man, if he come backside and put a rope in my neck, I can resist. I can jump. This is bound to occur as because he is also young. And also the learned advocate during the trial, the witness deposed that the Sunny was a young and healthy.
Nylon rope was recovered.
Nylon rope was purchased from a shop, and the shop owner specifically deposed that I do not recognize this young man. I am unable to recognize. PWC 16 is the photographer. He categorically deposed, I have no chips.
No chips.
Photographer always having a chips, but he deposed that I have no chips. And the nylon shop owner, PW17, he categorically deposed, I am unable to recognize this man. Now the question is that, Lordship, however the suspicion grave it may be, it cannot take the place of legal evidence. The prosecution miserably failed to establish the case beyond the reasonable doubt.
So allow her to.
She can, but I have just started the case. The real point is remain to be expressed, Lordship.
And you have said that there is no direct evidence.
No direct evidence.
36 witnesses, no, there is no direct evidence.
Yes, Lordship.
Now it is his duty to show us that chain has been completed.
Chain is completed or not. And then I will explain more.
So we can ask her.
Yes, yes.
It will cut short the matter.
Well, so far as my
So
lord,
yeah, show us the evidences. How you have complete the chain?
my lord,
Is
in
it
a,
is
in
it
a nutshell, if I
circumstantial
have,
evidence case?
well,
The case
this
of
is a case
circumstantial evidence.
that is based on
So you,
circumstantial
according to
evidence.
him, the chain is complete.
My lord, so far as the evidence is concerned, my lord, this appellant was found in the company of the deceased, and my lord, the tower location was seized by the investigating officer, which confirms the presence of the appellant with the deceased at the relevant point of time.
At the place of occurrence where the murder was taken place.
My lord, his body was found from the garden of PW 7.
In that place, his trial location was there.
No, my lord, prior to that.
Maybe prior to that.
My lord, what happened is there is a girl involved, both the deceased and the appellant. My lord, there is a girl involved, both the appellant and the deceased were in love with the same girl.
That is the motive part.
My lord, no, my lord, why I'm saying is this girl went out with the deceased. They met the appellant there. Now, this appellant took the phone of the deceased with him.
Appellant took the phone of the deceased.
Of the deceased. And he sent a text message to the girl's parents.
Okay.
To the deceased's parents.
Yes.
So, my lord, so far as the presence is concerned of the deceased in the company of the appellant, that stands proved from the deposition of the. My lord, I will.
He took the deceased phone, you have said.
Yes.
So how? Whether trial location is there of the accused?
Yes, my lord, that has been confirmed by the investigating officer. If your lordship turns
in the place of
page
occurrence.
82.
On the place of occurrence.
My lord, they were together. Till the time they were together, the tower location
So
shows.
that girl was also there.
My lord, after that the girl had left.
After that means?
My lord,
after occurrence.
Lord, if I may be permitted to place on record the evidence one by one.
Hey, record the. Yes.
My lord, I will first place on record the deposition of the girl, PW 6.
PW 6, page number?
Page number 13. Now, 29.
13 of.
My lord, 29 of the paper book. PW 6. The deposition of Mohita Ghosh Rimpa.
Who is he? Who is she?
My lord, she is the common love interest between the appellant and the deceased.
Well, that has been brought on record that he is the common lover.
Yes, my lord, and has been confirmed by the friend of the deceased also.
So, PW 6.
PW 6.
Please read.
On 27th of November 2014, I was also a student of class 12 of so-and-so school. One Shubhroto sir was my private tutor for English subject. Then one Rupak Tarafdar, Trishita Dotto and Shaunchari are also the student of Shubhroto sir. One Sunny Sheel is the deceased, since deceased was known to me. On 28th of November 2014 at about 9:30 a.m., said Rupak called me through mobile and stated to me that the mother of Sunny.
Sorry, madam. Rupak means the accused, appellant.
Rupak is not accused in this case.
Appellant's name?
Appellant's Rabin Singh.
Rupak is PW 9.
Okay. Rupak
He's
called
the
me.
friend of the deceased.
Rupak called me through mobile.
Rupa called me through mobile and stated to me that the mother of Sunny called him through mobile because Sunny was missing.
Oh.
This is the first instance when this girl comes to know that the deceased had gone missing. And she comes to know about it from the deceased's friend Rupak. Accordingly, on 28th of November 2014 at about 10 a.m., I myself, the said Rupak, went to the house of Sunny, and the mother of Sunny stated to me that Sunny is missing from yesterday and whether we are aware about Sunny or not. But I replied that I do not know anything. Thereafter, I returned to my house. On 2nd of December 2014, in the evening, police, New Barrackpur police station came to our house and thereafter took me to Modhamgram police station, and the police of New Barrackpur police station asked me about the matter of conversation which was made between me and Sunny. Police Dattapukur police station also asked me about the same matter. My date of birth is on 27th of November 2014. On that day, I went to the city center 2 at Salt Lake with my mother and parental uncle to purchase a sweater on the occasion of my birthday. Now, on 2014.
And she was deposing when she was 1 year old next year.
This would probably her birthday that she went to celebrate, my lord. Could be a typographical error, but my lord, this is what I'm assuming. On 27th of November 2014, Sunny called me on my phone 7 to 8 times, but I did not receive the same. However, I received his last call. Then he stated to me that Sunny likes me, and whether I like him or not, and whether I will stay with him always or not. My lord, this is the place where she discloses that the deceased had disclosed his interest towards the lady. However, I told him to call me again, but now I am not in a position to talk with him. Thereafter, I disconnected the line, but he called me through mobile at random, and finding no alternative, I again received his call, and then he stated to me the same version, and I replied that, okay, I will stay with you, but you do not call me again. Thereafter, I disconnected the call. Thereafter, we left city center and we were returning by bus, and then I sent a message to the mobile of Sunny stating, "What are you doing?" Sunny replied, sending a message stating that he is at Chowmin Center situated near my house. Thereafter, Sunny again sent some messages in my mobile, but it was my presumption that there is otherwise, and Sunny did not send such messages. My lord, I am beseeching your lordships to underline this portion. She had a hunch that these messages were not sent by the deceased himself, but somebody else was using his phone to text her. My lord, which stands proved in the other depositions, my lord. After returning to my house, I went to the house of my Didi, Devoshmita Bishash, and while I was in her house at about 10:15 p.m., I got a phone of Robin Singh, that is the appellant, in my phone, and he asked me over phone to come out of the house of my said Didi, and he made a wish by saying happy birthday and gave me a Cadbury, and he left to me. Thereafter, I again went to the house of the said Didi and called Sunny through his mobile phone at about 11:45 p.m., but my call was not received. Though I got a message sent through the phone stating that my father is in the house, I could not attend your phone. In my reply, I sent a message to Sunny stating that তোর কথা তো আমার কাছে তুই কাল খাতা তো আমার কাছে তুই কাল কি করে পরীক্ষা দিবি. But he did not reply. However, I also did not make any contact with him. Identified the appellant in court. I had love affair with Robin Singh while I was a student of middle class of class 11. My lord, here she expresses that she had an affair with the appellant himself. Well, I heard that Sunny died at Dattapukur. I also heard that Shiv killed him with a nylon rope. My lord, Shiv is the other name of the appellant, Robin Singh. I myself and Sunny were good friends, and subsequently I came to know that Sunny loves me. Shiv asked me what was the relation between me and Sunny, and I said we are good friends. On 23rd of November 2014.
How her evidence is?
Well, this is the part where she discloses the enmity between the appellant and the deceased.
Motive, maybe motive.
My lord, yes, so far as the motive is concerned, my lord, there is motive that both of them had the same, both of them fell in love with the same girl. And my lord, in this portion, she specifically stated that on 23rd of November 2014, Robin Singh, that is the appellant, slapped Sunny and asked why did he, and when the deceased asked why did he do so, he replied that he had asked some questions to Sunny about the friendship between Sunny and this lady. Thereafter, I called Sunny through the mobile number and asked him whether Robin Singh had slapped him or not. Then Sunny replied, yes, Robin had slapped him because he told a lie. However, he had disclosed the truth to Robin Singh about our friendship. But so far as the motive is concerned, this is transpiring from the deposition of this lady that there was enmity over the same person that both of them liked. My lord, now the deposition of the friend of the deceased, if your lordships turn to page number 37, PW9, Rupak Tarafdar. Lord, on 27th 11, I was also residing in my house, etc., etc. My lord, if your lordship comes to 5th paragraph from the top, I was aware of the love affair between Sunny and one Rimpa. Rimpa is the girl, PW6. On 28th of November 2014 in the morning, the mother of Sunny called me in her house. The father of Sunny also called me on that day in the evening, and they stated to me that Sunny had gone missing. Hearing it, I contacted with Rimpa over phone and told her that Sunny is missing and also asked her whether she knows about the whereabouts of Sunny. She replied that on 27th of November 2014 in the evening, Sunny called her over phone on several occasions. Thereafter, Rimpa stated that মনে হচ্ছে Sunny তার সঙ্গে মোবাইল কথা বলেনি, অন্য কেউ কথা বলেছে. Lord, she had a hunch which I had shown to your lordships when I read out the deposition of
whether this mobile phone of Sunny was recovered from the possession of
appellant. Yes.
You have to this mobile phone of Sunny was recovered from the possession of
Not the possession, Lordship. Absolutely.
At the instance of this appellant, the appellant has shown where he had kept the mobile phone. And he has led the investigating officer to that place.
So that evidence I want to see. I want to see that evidence.
Madam, the girl says that there was an affair between her and Sunny. She would not recognize whether the voice on the other side is of Sunny or not.
But that is
She says it was my hunch.
Absolutely.
But that is what I'm pointing out, my lord. She had a hunch that the words were not spoken by the deceased. She had a hunch that somebody else was using her phone.
The voice she would not recognize. Her boyfriend. Don't you find it a little strange? Anyway, sorry, you can't improve on what is there.
So I want to see that that evidence when it was recovered from whom or what is the evidence on that point.
Oh.
My lord, page, this was confirmed by the friend of the deceased that this mobile phone is of Sunny, which your lordship would find on page 38. But the recovery of the mobile phone was also videographed, which your lordship would find on page 27. But on page 38, the first paragraph, page 38, this is the deposition of Rupak Tarafdar.
58.
38.
What is the name of the witness number?
Well, this is PW9, Rupak Tarafdar. Page 38.
37,
First paragraph. On 1st of December 2014, I came to know from the local people that accused Sheep alias Robin Singh took Sunny at Dattapukur and thereafter He killed Sunny with a nylon rope. Sunny used a Nokia mobile set with double SIM, blue in color. In court, the PC period, Shiv alias Robin Singh handed over the said mobile from his rented house at New Barrackpur, which was kept in the said bag. I could identify the said phone.
No, whether he was a seizure witness.
Well, the seizure witnesses
No,
are
no, whether why you are referring this one? He came to know from this is hearsay evidence.
Hearsay.
My lord,
Hearsay.
Please
no,
take
my
your
lord, this was
seat. Why
produced.
Sandy? It will take
Lots.
some time.
Lots.
No, my lord, what I'm trying to show is this
No, no,
was
no. What
produced.
you are trying to
The
show?
phone was identified by this.
Maybe identified that this phone was the
My lord, that I'm showing. My lord.
belong to Sunny. But how it was recovered?
My lord, page 27.
27.
I made a videography of the recovery of the mobile set by Robin Singh, which was kept in the sandbag.
I am a
covering with
photographer by
plastic.
profession. I took snap and called me.
The last line of the second paragraph.
Sigil list witness. He is a sigil list witness.
No, my lord, he just captured the video.
And what is the recovery statement
My lord, I'll just take.
under section 27? Whether it has been exhibited. That
That I
if
need
you
to
take
look into the
me to
DCR.
this place, I shall recover the phone. This is a vital statement. You know, I think.
You see, there would be a statement to the effect that take me to my rented accommodation. The phone is hidden in a sandbag.
That document I wouldn't have. That would be a part of the TCR. If I've been permitted
That
to.
must be exhibited. That should be exhibited.
Lord, if I've been
Recovery
permitted
statement.
to look
Yes,
into
yes.
the
You can,
exhibits.
hey, trial court record में दिए दिन. That's why I've told you before recess. PCR is required. You said that the paper book is there.
Lord, I did not say
No,
something.
is a experience.
Lordship, if only one thing. PW4 is the father. He deposed the court that Baba Ami Rupak Songe Achi. Baba Ami Rupak Songe Achi. He was along with Rupak. I am coming soon. And Rupak phone was not seized deliberately in order to ascertain. At page number 20.
Rupak was also a lover. Where is this evidence in your cross-examination? Please show us.
At page 20, Lordship. PW4.
You have put this question that you are also a lover of Momita. You should not take the name.
Lover of.
Is there any evidence?
No, I am.
Have you
Lordship.
made this case that you are also a lover of Momita? Have you given suggestion?
Yes.
28.
I am on page 20.
20.
20 is the father. He deposed in para 3 at about 10:15, 10:13. I myself and my wife received a message in our respective mobile that from the mobile number of my son Sunny stating that Baba Ami Rupakir Songe Achi. Ektu pore aschi.
This is the prosecution case.
Yes.
That the appellant took the mobile phone of deceased and sending
Rupak is
so that nobody can
Lordship
suspect him. That is their case.
Rupak is not the appellant.
No. I am not saying about Rupak. This statement was done by you, your client. Okay, to entangle Rupak. This is the case of the prosecution that you stole his mobile, and from that mobile you are saying, I am with Rupak.
True, Lordship, but I am asking myself, if the Rupak name has been transpired, it is the duty of the prosecution to take over the
Now,
phone of Rupak.
What is the cross-examination of Rupak by you?
Yes.
Yes. I will make this defense case.
PW9.
PW9, tell me. You give It is not a fact that I wanted to love Grimpa.
And in the last
It is not a fact that my relations deteriorated due to such love.
page number 41, it is also true that I did not narrate the police that she kept such phone in a sandbag at page
At page
41. 41.
41.
After two lines.
Yes.
It is also true that I did not narrate the police that she kept a mobile phone in a sandbag covered with the plastic.
No, I am not saying that from the mobile phone of Sunny, the father of Sunny received the message that I was with Rupok. Have you put this suggestion to this witness? No. Yes. Now, prosecutor.
Of the appellant pursuant to which the mobile phone was recovered.
Yes.
Look, this is the statement which has been exhibited as exhibit number 23.
Under section 27 of the Evidence Act.
27.
What is the exhibit?
Exhibit 23. It's written at
No,
the
no,
back.
this is not. What is this? Is only that portion. It's not a recovery. It is
Entire statement in which
the
it is
entire
stated.
statement cannot be with objection. Objection is there. Only that portion I shall recover if you take me. Only that underlying portion. Okay. You shall put. Now tell me. Where is the seizure list witness?
Witnesses are one is PW9 and the other person is PW19, which your lordship would find on page
Oh, please
55.
show us the seizure list. এই দিন তো ওটা seizure list এর মোবাইল ফোনের seizure listটা কোনটা দেখিয়ে দিন। One Nokia blue color, Rupok Tarofdar and Saurabh বিশ্বাস. And another is Saurabh. Whether Saurabh বিশ্বাস has
Saurabh Vishwas, your lordship would find his deposition on page 55.
now Rupok Tarofdar was a seizure list witness.
Yes.
So whether
And he has also identified the phone in court when it was presented in
PW9 has said
his Rupok Tarofdar. Yes, my lord, page
Rupok,
38,
Rupok.
first paragraph.
I came to know from local people, skilled him. Well said.
In court PC period, Shib handed over the phone from his rented house.
Nokia mobile set with double SIM in court of PC period. Gobind Singh handed over the said mobile from his rented house at New Barakpur, which was kept in a sandbag.
I could identify the said phone and police seized the said phone in my presence.
Yes.
And also in presence of Shiv Robin Singh and Saurav, my cousin. Saurav is PW19, whose deposition is on page 55, and prepared a seizure list on which I put my signature. I could identify the signature of myself, Shiv Robin Singh, and my cousin. My lord, apart from that, my lord, the Aadhaar card and the wallet of this deceased were also seized from the appellant, my lord, at the instance of the appellant, and that has also been exhibited.
Now we have
Yes, Lordship.
okay, complete. This is one circumstances why this phone of deceased was seized from the possession of the appellant.
Yes.
Okay, yes, it is a.
The second point is, my lord, the wallet and the Aadhaar card of the deceased were also seized at the instance of the appellant. My lord, that your lord.
Aadhaar card.
Aadhaar card of the deceased.
Phone was seized. It has been
My lord, if your lordship turns to page 47, this is PW 14 Mrinal Kanti Das. He
W
is
14.
PW 14 Mrinal Kanti Das. He is the witness to the seizure of the wallet and the Aadhaar card.
Wallet and Aadhaar card. What you are doing with the Aadhaar card of deceased?
Lordship, if
No,
a
I
part-
will come. I will come.
Lordship.
I've given you scene paper. Questions are now seen to you. You have to answer.
Lordship.
Wallet and other cards are found.
That deposition, your lordship would find on paragraph 3 of the witness PW 14. On 2nd of December 2014 at about 12:15, 12:20 p.m., the police took a person where the dead body of the said unknown person was lying. Subsequently, we came to know that the person who was brought by police is named Robin Singh. Thereafter, police asked the said Robin Singh in our presence where he kept a money bag, and accordingly, Robin brought the said bag and from a drag of garbage. He also found a Xerox copy of the Aadhaar card from the said from that money bag. Robin Singh opened the money bag and showed some papers. But
It was,
this is also exhibited.
when it was recovered.
But 2nd of December 2014.
So there was recovery statement.
My lord, yes, my lord. That is also there. My lord, I'll show it to your lordship.
Please read. Read specific portion that if you take me to there, I shall help to recover phone, other card. This portion. That is part of the right.
But this is the statement.
তো তারপর ট্রেনে উঠে দেখি আমার পকেটে আমার মানি ব্যাগটা নেই। ও ইয়েস, মনে হয় যখন আমিকে মেরেছিলাম তখন ওখানে পড়ে গেছে। আজ যদি আপনি আমাকে নিয়ে যেতে চান, এই দিস ইজ নট হেল্প ইউ। মানি ব্যাগ অফ অ্যাপেলেন্ট ওয়াজ lost according to this version. This cannot be accepted. He মানে ওকে হেল্প করার জন্য ওকে বন্ধ আমি আমার
But and the seizure witnesses are PW.
I thought that the other card of victim,
No, the appellant.
money bag of the victim.
The appellant. Money bag and the Aadhaar
Maybe
card. My lord, apart from that,
is
my
for
lord,
the framing of the accused, it may be.
but they were together. My lord, that is what is transpiring from his statement. My lord, and so far as the tower location is concerned, if your lordship turns to page 83, the deposition of
When the body was recovered,
That body was recovered from the garden of PW.
On. On 28/11. 28/11/2014.
Yes,
A
but
dead
that
body was
the
found of
owner did
unknown
not
person.
state it.
Okay.
Yes, but that the
And
owner did not.
in the vicinity of place of occurrence or in the place of occurrence, he left the money bag, according to you. Now this recovery was done on 2nd/12. That means after 4 days.
After 4 days.
Is it believable? No, I cannot believe this one. Okay. Next point.
My lord, if
Now
your
you are
lordship
trying your
not-
best. I appreciate.
My lord, grateful, my lord.
Yes.
My lord, if your lordship now turn to page 82, this is the deposition.
Yes,
of 82.
Page
82. My lord, PW 31. He's the investigating officer. He's one of the investigating officers, my lord.
82.
82, my lord. The third paragraph from the bottom. I collected the call details and tower location also, from which it was found at the time of incident the tower location of the deceased and the accused was under Dattapukur PS. Thereafter, the tower location of the accused was changed from Dattapukur to New Barrackport. And as the mobile phone of the deceased was seized from the accused, the tower location of the mobile set of the deceased also changed similarly with the accused. So this shows that the appellant and the deceased were in each other's company.
This is your question. Note down. Next.
My lord, he goes on that thereafter the accused created messages from the mobile set of the deceased towards Momita Ghosh. My lord, the messages and my lord, the PW6 also had a hunch that the words which were spoken to her may not be.
What is the purpose? Please, carry.
But thereafter, the accused created messages from the mobile set of the deceased towards Momita Ghosh. My lord, this was confirmed by the.
I can't get you.
My lord, the appellant used the phone of the deceased and sent messages through the phone of that deceased.
Yes.
This was stated by the friend of that deceased, PW9. And this was also confirmed by the investigating officer, and he also sent the CDR to FSL. No, my lord, he just seized the CDR. I seized the CDR by preparing a seizure list on 19th of December 2014 at 16:45 to 16:50 hours at Dattapukur PS. This is the carbon copy of the seizure list, prepared and signed by me, prepared in the same mechanical process, which has been exhibited as Exhibit 18. I obtained signatures of the constable, so and so. Lord, so far as the presence of the petitioner of the appellant in the company of the deceased is concerned, my lord, the tower location confirms the same. And my lord, the statement of under 161 of the appellant also confirmed that when he had.
Appellant's 161 means?
My lord, the
accused statement.
Accused statement pursuant to which the money bag and the Aadhaar card.
Is only that portion may be accepted under section 27.
Yes, but
that portion.
Yes, but he has confirmed that when I was in his presence, when I was in his company, that has also.
Oh, that is 27 does not allow.
Very
Only
well,
recovery portion.
Very well. So far as the presence is concerned, my lord, the tower location confirms that they were in each other's company.
Circumstantial evidence.
Yes. Circumstantial evidence, but my lord, establishes that they were in contact with each other before the deceased.
Saurabh has been examined. Yes.
Yes, so Saurabh has been examined as PW 14.
He has also stated.
No, PW not 14, PW 19.
No, PW 9 is
19, my lord. PW 19 is Saurabh Biswas. He is the seizure list witness to the recovery of the 19, page 55.
Yes.
Third paragraph from the top. I put such signature on the paper on 2nd of December 2014 at about 5:45 p.m. or 6 p.m. On that date and time, Robin Singh found out a phone blue in color in my presence and the presence of police personnel and others from a sandbag which was at the place beside his rented house. So he has witnessed the recovery of the phone of the deceased from the rented accommodation of the applicant.
Videography is also there.
Yes.
Video has been marked as
Exhibited, my
exhibit.
lord. Yes. Lord, that your lordship would find on page 27, PW 5. Amit Bose.
Page number?
Page 27.
Yes, tell me.
Lord, I took a snap and also make videography of any occasion as per call on 2nd of December 2014. Police of New Barrackpur police station called me and I went thereon. Thereafter, some police personnel of Dattapukur police station took me in the house of one Renuka Sharkar in D2 Bagar with a vehicle from New Barrackpur police station. Thereafter, I made a video photography of movement of Robin Singh from the gate of the house of Renuka Sharkar to the bathroom of a house. I made a video photography of recovery of a mobile set by Robin Singh, which was kept in a sandbag covering with plastic. Accused Robin Singh identified house of Renuka Sharkar. After making such videography, I handed over the video cassette.
Now, whether all these incriminating statements are placed before the accused at the time of examination under section 313 CRPC is a very vital thing.
Yes, my lord, but
Because
he has not furnished any explanation to that.
He has to be given an opportunity to explain. If that is complete, then we shall ask the accused to, not accused, convict. Now you go through the section 313, whether explanation is called for.
Well, at page 117 onwards, question number 63 onwards, my lord.
Page
117, question number 63.
117.
117, question 63.
Question 63. Yes.
PW 19, Saurabh Biswas has stated in his evidence that he put his signature on the paper in the rented house of you at New Barrackpur in presence of police. What do you want to say? I do not know. Plot page 118, question number 64. PW 19 further stated in his evidence that police prepared a paper against such mobile in their presence in which he, his cousin Rupak, and you also put their respective signatures, and he identified his signature and the signature of you. What do you want to say? He said false. Then, my lord, question number 65. PW 19 has further stated in his evidence that he put such signature on the paper in the rented house of you at New Barrackpur in presence of police on 2nd December 2014 at 6:15 p.m. to 6:30 p.m. What do you say? False. I put my signature at PS.
The police collected black color set when police called me for first time and collected from my house.
Yes, Milord, this is the rented accommodation of the applicant.
No. So whether he has admitted that it is collected from his house. What is there, Mr. Counsel?
Black color set.
What is it? Police collected.
Police collected black color set from my.
When police called me for first time and collected from my house, the blue color set, you admitted.
Blue color phone.
But the admission is.
No, I am saying that there is no denial. It appears to me because he is at the back end of our argument. That's why. Now you get ready.
But he is telling that police collected black color mobile. That mobile's color is different.
But he
Black
also
color
mentions
set.
about the blue colored set.
When police called me for first time and collected from my house the blue colored set.
The blue colored phone belonged to the deceased.
Whether this
That is
you
black
want to
color.
know you know the law, you know judicial decision so far as section 313 is concerned, whether the incriminating materials, evidence is properly brought to the notice of the accused or not. That has been correctly done. Now, what is your answer? I do not know.
Lordship.
You shall explain. Okay.
Lordship.
So you may complete. Okay. Anything else, madam?
What is
The nylon rope.
PM report?
The post-mortem report, your lordships will find on page 11.
PM report is not exhibited.
Death was due to the effects of triangulation by ligature, as noted above, antemortem and homicidal in nature.
11.
The autopsy surgeon has also mentioned in his deposition that the death could have been caused by the nylon rope. Your lordship would find that on page 62.
Now, death was due to the effects of strangulation by ligature, as noted above, antemortem and homicidal in nature.
Yes, so this is not inconsistent with the prosecution
Yes,
case.
Lord, if your lordship now turn to page 61, this is the deposition of the autopsy surgeon, Dr. Supriti Ghorai. But if your lordship now turns to page 62, page 62, this is the deposition of the autopsy surgeon.
Yes.
But right before the cross-examination at the bottom, he stated that the injury sustained by the said deceased is not self-inflicted.
62 or 63?
62. My lord, it starts from 61.
Yes. It's not self-inflicted. Yes.
Yeah, it's not self-inflicted. Such type of injury may not be caused if a person falls on a hard substance. To see Mat Exhibit 6, the ligature on the neck of the deceased may be caused out of the use of such type of Mat Exhibit 6, that is the nylon rope. Well, this nylon rope was sent for FSL.
Nylon rope was recovered.
It was lying where the dead body was recovered. Now, whether or not this particular nylon rope had been purchased by the appellant, that there is a question mark so far as that particular question is concerned. But
it may not be a new one, that it is a maybe old one. He collected from
the person from whose shop the nylon rope was purchased, he has deposed that a boy had indeed come to his shop to purchase a nylon rope. Lord, that deposition your lordship would find on.
So when he will come back?
PW 17.
PW 17.
Page.
Testable page.
Page 51. Subroto Sen. PW 17.
Page?
Page 51.
Could not identify.
Lord, he did not identify the boy who had come to his shop. But my lord, a fresh rope was taken from his shop, and the rope which was found next to the dead body, both were sent for FSL. And my lord, it matched.
Okay. Anything else?
But that particular evidence your lordship would find on page 93.
93.
Madam, we'll have to stop here today. Please come back next week, because on Thursday and Friday this bench is not available. Right? So we'll first hear you out fully, then we'll hear your side.
Lots.
We have heard learned counsel for the parties at length. Stop. Paragraph. List the matter once again. এটাকে priority দাও, এটা যেহেতু শুরু করে দিয়েছি আমরা এতটা করেছি। Monday as the first item under the heading criminal appeal hearing.
Lots. Deeply.
Really true.
Tuesday. Tuesday.
Oh, this matter you're appearing. Oh, yes.
He has done very.
Tuesday.
Hey, এটা রেখে দিন।
হ্যাঁ?
बाद में दे देंगे ना।
बाबू
यही है ना, बाद में पूरा दे दिया जाएगा।
আমরা শিফট করেন, আমরা দিয়ে পুরো শিফট করি। এটা বলেছি করুন, তারপর আমরা কারেকশন করে দেবো না। এটা নিন।
চেম্বারে বসো স্যারকে, কি আশ্চর্য।
তারপরে বসে আছি। 174202. One seven four two zero two. Original side matter, new application item number 1.
I'm not just Rashid, but may I be permitted to mention a matter? This is before the other bench where your lordship is presiding with Justice Omnara and Rai, the Exide matter.
Yes, we'll sit in 5 minutes time.
My lord will take that up in 5 minutes. My lord, I'm online, my lord.
Yes?
Your lordship will take the Exide matter in 5 minutes?
No, Mr. Luthra. Today there's no time. There's a full court
I
reference.
understand, Lord. Today your lordship is the full court. Not the only.
That bench will be assembling for 5 minutes. In 5 minutes time.
5 minutes. We will come back, Lord.
When we can fix a date. When
That's
we can...
all. That's all. That's all. Lord, grateful, Lord. That's all we will ask. Grateful, Lord. Deeply. We'll wait.
Item number 2.
One টা কি হলো? One is
Your lordship, in item number 1, I'm praying for a short passover, your lordship.
Not today. Next.
The item number 2, my lord, is my lordship very urgent.
My lord, I'm for the resolution
Your
professional.
lordship, my lord,
Yes, sorry.
your lordship will have the time, but I'll tell your lordship,
No, because
Well,
we
in
have
that
another
case, my lord,
bench and then the reference, so no time.
my lord,
Today we
there
can't.
is grave urgency, my lord. Whenever your lordships can, my lord, find some time.
Monday, let it be listed on Monday,
Monday.
because Thursday and Friday, this bench is not available.
My lord, only problem is, my lord, this ultimately will determine the fate of a proceeding pending before the NCLT.
We understand
The
everything.
NCLT
This bench is not available. Go before some other bench then, Mr.
No,
Shah.
no.
I understand the anxiety of your junior and, you know.
My lord, you come back on Monday.
Hmm? Yes, you can come back on Thursday, but it will be a different bench. If we can't conclude, then again it will be a waste of time, energy, everything. This bench is not available on Thursday and Friday.
The entire urgency is, my lord, ours. We'll come back on
My lord,
Monday.
we will, my lord, only, my lord, make a request before the NCLT, my lord, not to take it up before Monday. My lord, your
My
lordship,
lord,
kindly, my lord,
matter, as I am told, it's been reserved for judgment, and the learned judge has made it clear that, my lord, till the time this judgment comes, they will not deliver judgment, because it would be a direct affront to your
if
lordship.
that is the case, then we are happy. But my lord, I cannot rely on what my learned friend says.
No,
my lord,
don't
in all
rely on
sincerity.
me.
But my lord,
I don't
That's
see
not a
why
good
you say
idea.
you will not rely on your learned friend's statement, Mr.
no, I'm
Shah.
saying, but I cannot.
No,
rely on
that
the
is what
statement
I
made
am
because
insta. I am not
sincerity.
briefed in the matter in
Because others,
NCLT.
but before the NCLT, my lord,
No,
my lord,
let's
really
not ask
flooding.
for, let's not get a stay in this way.
No, no, my lord, I'm not asking for a stay. I'm only asking that the matter, my lord, be taken up if possible at an. Only if it's possible to fix a time.
Monday, original side, 3 p.m. or after exhaustion of appellate side list, whichever is earlier.
Absolutely.
And your matter is number 2.
2.
Yeah.
Grateful.
Taku. Hey,
ठीक है, बैठ जाओ।
And item number 1.
Daro. Somebody was mentioning the Excite matter.
Yes, my lord. There was a mention by the other side. We are also here, my lord.
Thursday, this Thursday, day after tomorrow, 2 p.m.
Then-
Mr. Luthra,
Yes, no, that's fine, Lord. Mr. Lalit Senior will be arguing, so he'll conclude and then.
after tomorrow,
On this coming Thursday at 2 p.m. Well, I will not be in Calcutta on. I will be in court on Thursday, but I should to leave early for the purpose of leaving Calcutta. Well, I'm sorry, Malad. On Thursday and Friday, I've just now heard that this bench will be sitting on Thursday and Friday.
Yes, because the other bench will not be available.
So happened, my lord, that it has.
Then we can't give you a date immediately, Mr. Mitru. This bench will sit on Thursday at 2 p.m. because this bench has quite a few parted matters. So all the parted matters will be listed. We were willing to make your matter number one because
But it would have been very convenient. I tell you, Lordship, very frankly, I would have been very glad because I wanted to conclude my submissions in both the matters.
well,
Both the parted
in
matters.
that event, we really can't tell you now, next week or week after that, when we'll sit together.
Your Lordship will not be sitting at 10:30 on Thursday. If it can be done.
My brother has a separate determination, single bench, very important one.
I'm sure, my lord, your Lordship's learned brother, my lord, doesn't want to sit in that bench if your Lordship, my lord,
be proper. That won't be
fixes up this particular matter, my lord. Well, I'm so sorry, my lord. I can be here till 2 o'clock.
Then let us see next week. We'll sit again.
Next week.
Your matter.
Mentioning that other matter.
Yes, there, my lord, I will not.
Pipeline matter.
Yes, gas pipeline, half a day will be good enough for me.
Yes, again, you are not available. You have JSOP also.
I think it's all Mr. Mitra's.
Yes, so we'll have to see. We'll have to see next week or as soon as we can.
Yes, I mean, any day, my lord, I am feeling embarrassed because, my lord, your Lordship will be sitting on those 2 days. I will not be available.
All right, let us see.
On personal ground, I feel very hesitant in asking for adjournment. But it so happened, my lord, I will have to go.
Mr. Mitru, we'll do this. We'll sit on Thursday and Friday. All our partnered matters will be listed. Whoever is available will do the matter. Whoever is not, we are not going to dismiss.
I'm sure.
Your
Lordship.
That's it.
Very well. On that day, my lord, if I am not here, when somebody will mention the matter, my lord, and
your matter may not even be called on. We'll ensure if it's the last partnered matter.
Very well, my lord. Let it be there.
Because we are sitting definitely on Thursday.
On Thursday and Friday. Very well.
And after that, when we'll sit again, we can't tell you now.
Yes, I can very well understand.
But whenever we do, the matters will be displayed with the list at least 2 days in advance, so that all learned lawyers get sufficient notice. All right.
Grateful.
Yes.
Only one request, my lord, if the Exide matter can get some preference, even when it is listed.
Next, Mr. Rajudhuri, we don't have time. We'll be writing now.
If the matters would be there, the partnered matters, then, my lord, we don't need to mention.
Don't mention. All partnered matters will be listed.
All partnered matters. We shall see.
বৃহস্পতিবার 2টোর সময় all partnered matters will be listed. No, সেটা তুমি সোমবার থেকে ডিসপ্লে করবে বা জাজমেন্টটা কোথায়? You're for the respondent.
I'm for the appellant, my
We have found the appeal to be not maintained.
This is only in respect of one of the 8 appeals, because
One of the,
there was a bunch of 8 appeals.
yes.
This order was reserved in only one of the appeals. So other 7s.
You see, the difficulty is,
Same matter.
Mr. Ghosh, we don't have determination as of date.
I leave it to your lordship.
So you will have to, no, this whole question of leaving it to us. We don't have determination. So either you will have to get it released and bring it before us, this bench, or this may be followed by whichever bench. Identical issues.
Inter-party, my lord?
Yes.
In nature of section, my lord?
Yes. Next.
To be mentioned, item number 2.
Great.
I
appear for the respondent.
We are recalling that order. We need to reconsider.
Very well, madam.
We need to reconsider. Right? So this matter will be listed again on an appropriate date when this bench is available. You are for the appellant is not here.
No, my lord. If there is any particular question, my lord, if I then I can come and prepare,
Yes,
my lord.
please consider there is no specific bar in Commercial Courts Act in transferring a suit wrongly filed in one division to another division.
I understand.
Why can't 151 be exercised for the ends of justice?
I had that answer ready, but my lord, whenever it comes up, my lord.
You are appearing.
I am for the appellant.
Yes, কবেকার order ছিল ওটা দেখি। This matter লিখুন। This matter has been listed at our instance. Paragraph on October 31, 2025, we had disposed of this matter by dictating a judgment in open court. Stop. We have not signed the judgment as yet. Paragraph on further deliberation, we are of the view that we need to reconsider the issue involved. Paragraph, the order dated October 31, 2021 stands recalled.
It was perhaps not uploaded in the server yet.
No.
Open put so it's an order. An order nevertheless.
Signed when server to hobe ki kore? The likhlam to signed right. We have not signed.
Next week রাখবে হয়তো Thursday or Friday বসে।
ওপেন কোর্টে প্রোনাউন্স করেছি তো রিকল করতে হবে না? Is recalled, stands recalled. Paragraph lists this matter once again under the heading for further hearing. Whenever this bench is, Friday Friday. This Friday. Friday date ta diyo. We'll be assembling at 2 p.m. possibly. We have carefully considered Justice Sen's division bench judgment again carefully.
Very well. But since since there is a specific provision under Order 7 Rule 10, Millard, perhaps by Justice Millard, by Manohar Mandal Millard, that 1962 judgment, perhaps Millard 151 will not be applicable.
No, that's for return of claim.
Since there is already a specific provision for return. Yes.
But why not transfer? Same court, 2 division.
I understand what is falling from my lordship.
Anyway, we have a full court reference.
Yes, we come back on Friday.
Deeply obliged, my lord. Deeply obliged.